referencing that during either opening statements or closing arguments.
Good morning, everybody. How we doing?
For the record,
we're just jumping in here right away. I apologize for no forewarning, but we were going to start at 9. But
page and a half is from my judicial bench book. I thought it would be helpful to you that you have a better awareness and understanding of the manner and purpose of an opening statement. This is what guides me as I preside over cases.
Okay, I set for value in return for value these documents. I don't know why the reference to subject matter jurisdiction in the opening statement. I'm pretty aware that that wouldn't be part of an opening or closing statement. I don't.
Okay, great.
I don't get why that's
I wanted to make the record
because you
clear.
will never.
So I appreciate you indicating to me that you're aware of that.
Even though subject matter jurisdiction has not been proven on the record.
And there we go.
And should be addressed.
Does not need to be proven on the record. It's established by law and by the fact that, as my written decision indicates, commenced when the criminal complaint was filed in this case. It's conferred by Constitution and by statute.
And who was the complaint filed by? Because subject matter jurisdiction has yet to be proven on the record. I'm not going to go down this path
today. I'm just advising you cannot reference that in your opening statement.
That was something I've already had the common sense to know, but also subject matter jurisdiction has not been proven for the record.
No, you just said he had common sense.
Next topic, then. I believe the state has filed
should be proven for the record by the prosecution.
The objection is noted. It is not legally sound. It's overruled.
It's definitely legally sound.
All right, Attorney, I'm going to turn to Attorney Opper. I believe they filed a motion this morning. Has it been pulled through? I probably just need to refresh.
The mics over there are running really hot right now, so my apologies. I can't control their mic.
Last night in the jail, Your Honor.
All right, go ahead. You can make.
I didn't look at the document. I accept the return.
Share the stream, please.
Return for value the document. I didn't look at it. So I don't know what I'm supposed to say to that.
All right. Well, Attorney Opper, it's your motion. I'll hear from you.
Nothing.
Your Honor, we are moving to amend the information with respect to one word in the entire document. We're asking to change the location of count 76. The information reads as it reads right now. It reads at Frame Park. We're asking to change that to near Frame Park. We believe that that's a more consistent statement that aligns with the testimony of victim PPP, Erica Patterson, as she testified in this trial. We're not asking to change any criminal charges. We're not asking to change any dates. It's, I think, a very small change in the charging document. The defendant has been on notice of the facts of this transaction. It's reflected in a number of police reports and Ms. Patterson's recorded statement, which the defendant has copies of. And so I don't think that there's any grounds for a claim of prejudice by this change, and we're asking to move forward with that amendment to the information.
All right, thank you. Any position on that, sir?
Yes. First of all, for the record, there were originally 2 charges associated with this one party, and these charges have been charged for the better part of a year. I feel that if there was essentially one word that needed to be changed, it's been more than ample time for it to be changed. Even after one of the charges was dismissed, it could have been, that topic could have been visited at that time for it to change. I don't think changing one word at this point really has any bearing on the testimony or the actual charge. I don't understand why a motion needs to be heard about one word. Is I think kind of at this point kind of a moot point. it's been charged like this for a year, basically. But the language hasn't ever been referenced to being changed before yesterday. So what is the significance of this now at this point?
Thank you, sir. Court is guided by section 971.29 sub 2 of the Wisconsin statutes, which provides at the trial, the court may allow amendment of the complaint, indictment, or information to conform to the proof where such amendment is not prejudicial to the defendant. Case law states that when an amendment to the charging document does not change the crime charged, and when the alleged offense is the same and the results from the same transaction, there is no prejudice to the defendant. State versus Wickstrom, 118 Wisconsin 2nd, 339, found at page 348. It's a Court of Appeals case from 1984. And also, I point the parties to State versus Durango, 229 Wisconsin 2nd, 1, and State versus Gerard, 189 Wisconsin 2nd, 505. The first of those two cases is a Court of Appeals case from 1999, and then the second of those referenced is from the Supreme Court from 1995. I'd also point the parties to State versus Frey, 178 Wisconsin 2nd, 729, a Court of Appeals case from 1993. As far as whether this is a moot issue or not, I'll find that it is ripe for determination by this court to hear this motion, and that is because the jury ultimately will be instructed similarly to what the jurors were instructed at the beginning of the case. The charges are read. Those are based off of the information, and this proposed amendment does conform to the proof. There is no prejudice to Mr. Brooks. It does not change the charge in any way. It is still the same offense. It's still from the same general information that was indicated in the criminal complaint. So for all of those reasons, I will grant the state's request to amend the information, and the state may file that document as soon as possible.
I have a question about that. So this same person is scheduled to testify again. What if something changes in the testimony?
I'm not going to answer that, sir. It would require me to speculate on what that situation might be and to give an advisory opinion, which I will not do.
But what happens if that happens?
I'm not going to answer that, sir. I can't. You're asking me to give an advisory decision. I'm not going to do that. I'm not allowed to do that, actually. Okay, so we dealt with that then.
Makes no sense.
The state has not rested yet. Will the state anticipate calling any other witnesses?
Yes, Your Honor, as indicated yesterday, we do intend to recall Detective Casey to the stand, and I'd like to make a record in that regard, please.
Go ahead.
Your Honor, Detective Casey did testify once for the state early in the presentation of the matter. His focus at that point was largely on assisting the jury in understanding the layout of the parade route, giving background and contextual information to the jury, the different parade units that were impacted, what they looked like. We showed several videos with Detective Casey just for background and context purposes. He then went on to describe his personal interaction with the SUV as it came through the intersection of White Rock and Main. And essentially, that was the bulk of his testimony during his first testimony. We're seeking to recall him now. This is not unusual. It is commonly done in cases. We never excused him from his subpoena. We never asked for him to be excused from his subpoena. We always intended to recall him. We did this so that we can efficiently present the information to the jury. The types of questions we have for him now go more to the investigation itself and his role as the lead detective in this case. There will not be duplication or repetitive questions. I'm not going back to the corner of White Rock and Maine with Detective Casey during this round of testimony. We want to ask him essentially about how some of the victims along the parade route were identified. We want to ask him about some of the topics that have been addressed throughout the course of the state's case, as far as identification of the vehicle and identification of the driver. And we need to still introduce the certified bail forms from Milwaukee County for the 2 bail jumping counts. So he will be asked about that. I estimate my direct examination of Detective Casey would be about 20 minutes. So this is not going to be repetitive. It's information, again, that he has as the lead detective in the case to assist the jury in understanding some of the things on the back end that he was involved in, not his role at the parade. So we have been very efficient in our presentation. I believe Your Honor would agree with that. We're not wasting time here, but we just have a few more questions to wrap this up.
All right. Any position from you, sir?
And yes, I do. And I'm gonna start with what was just said. The prosecution feels that they've been efficient in their presentation. So it seems like to me an attempt to get more questions in that could have been asked in the first place. If Your Honor recalls, Detective Casey was
it's due process, man. This is just how it
testifying
works.
for quite some time.
Just how it works.
To the point that we actually had to have a break before I can cross-examine Detective Casey, if you recall. He was up there quite some time. That was more than enough time for any other foundations to be laid, any questions to be asked at that time. And also, from my recollection, he was asked to be excused. So essentially having him start off and then end it, I feel like it's an attempt to get questions that was maybe forgotten to be asked, answered. And essentially what more could be gained by a second testimony from Detective Casey? What more can be gained that hasn't already been learned? We learned about vehicles and identification by numerous witnesses. We've been through the inspection of the vehicle. We've been through DNA analysis of the vehicle. We've been through numerous things in regards to the vehicle. Even the reconstruction testimony. We've been through all of that. Seems like nothing more than to get extra questions answered that could have been asked from the get-go. As seeing as how he was up there for quite some time and none of those issues were raised at that time. What would be the significance at this point? When it's essentially, I should be already presenting my defense at this point in trial. I don't see the relevancy of it.
He's trying to jump right in. So he wants to, start doing his defense. That's surprising.
His subpoena. So,
thank you, sir. Thank you, sir. The court has discretion.
Great share.
Under 906.11.
Good stuff.
It's a statute I've quoted with frequency during the course of these proceedings.
906.11.
I've listened to the state's offer of proof. I've listened to the objections made by the defendant. In my discretion, I am going to allow Detective Casey to be recalled for the reasons laid out by the state. As I understand his proposed testimony today, it is not to rehash topics that he was questioned about initially. This has to do with his investigation and role subsequent to the initial contact with Mr. Brooks at the beginning of the parade route. And as the state indicated, we'll address certain things, including identification related to the vehicle of the driver throughout the investigation, identification of certain victims. In addition, there are 2 additional charges for which the state has not yet presented testimony, so it's proper for those as well. It's relevant, and I will allow it for those reasons. So the state will be able to recall Detective Casey, and we'll have that done, obviously, when the jury is brought out. Any other preliminary issues then from the state?
Your Honor, just I am working on going through our list of exhibits, and I will work with your clerk to make sure that everything that I'm showing was admitted and accepted by the court is what she has, so that we can clear that up before we actually rest.
All right, thank you. Anything preliminary from you, sir?
Yeah, just a quick question about the last thing again. I will be able to re-cross-examine.
Oh, yes, you will.
And is essentially anything left off limits to my cross?
Examinate.
With
Another one.
I may limit, depending on where we go, if the questions deal with what he testified to previously, primarily to cross-examine based on the new testimony. However, 90611 also says this: witness may be cross-examined on any matter relevant to any issue in the case, including credibility. It does say in the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct. So I'll give you some leeway, and I'll trust the state will make appropriate objections, and I'll rule on them if and when they're made.
because I'm not intending to go too much back into the previous testimony, but I think it made a few points from the earlier testimony may come into play, and I just wanted to make sure
I think that's fair.
that wouldn't be a problem.
I think that's fair, sir.
Also, really quick, I did look over some information provided by the prosecution as far as the pretrial offer that I did not have knowledge of until, I don't know if that was today, Thursday. I don't know if that was Monday or Friday or Monday, one of those days. I've put together, started to, I won't say it's completed. That wouldn't be fair to say. I've put together or started to put together a counter offer. So I just wanted to advise the court that I was putting that together.
All right, thank you, sir. If and when you do provide that to the state, please let me know so we can make a record of that. All right, anything else? If not, then we'll have the jury brought out.
We do have one last large map here, Your Honor. I'm going to ask to put up and face backwards like we did the other day.
All right, go ahead since the jury's not here.
All right, guys, share the stream out now if you would, please. We want to make sure to get as many people in here now that the jury's coming in and we're setting up the next round of madness, guys. This is going to be the day of days. Darrell Brooks is going to start his what is he doing at the desk there? That doesn't look like you should be doing that in public. I don't. think he just pulled a little Amber Heard right there, man. Just disappeared off the table. Ready to go. Got that like some comment. He did some of the
All rise.
some of the Cheech and Chong. Just huffing Ajax, man. Sorry about the light, guys. I know it was a little harsh, man. This is the product of no sleep for about 3-4 days, but this is what you get. So in walks the jury now, and they've got a couple more fine housekeeping points that the prosecution is going to work on. They're going to be touching on the previous witness, a couple little questions they have to ask, a few things they have to do. Obviously, we just saw that he had objections to that because he objects to everything.
Please be seated.
But then he's going to open his case with his opening testimony,
I'm not sure if that will
opening
change
statement.
now that we're all in here. At any time that temperature is too
Share the
cold,
stream. That's all I can
let
say.
me
It's
know
going to be an
and we can
interesting
have
day.
that
I got a
adjusted.
video to show you where he had 52
Right.
outbursts yesterday.
Attorney Alford, you may
52
call
up
your
to
next
4
witness.
o'clock.
Thank
They
you,
went
Your
for another
Honor.
hour.
The state would recall Detective Tom Casey.
Good morning, Detective Casey. Please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat. Please state your first and last names for the record.
Thomas Casey.
Thank you. Go ahead, Attorney Alford.
Thank you. Detective Casey, I'd like to begin by asking you to refer to the item behind you. There's a large poster board there. If you could please place that on the easel and identify the exhibit number for the court.
It's exhibit number 15.
Thank you. And we've had testimony about this exhibit throughout the trial. Is that right, sir?
Yes, we have.
All right. Your role in this case was what, sir?
Objection leading.
Overruled.
Initially, I was on traffic control for the parade. Shortly after the incident happened, I was assigned as lead detective for the case.
Were you the individual who created this map, States Exhibit number 15?
Yes, I did.
Okay. And I would like you to talk a little bit about how victims were identified in this case.
Objection leading.
Overruled. Foundational. The witness may answer.
So at least initially, can you tell us, like, in the day or two after the parade, what happened?
Objection leading.
Overruled. You may answer.
So initially, that night, we knew that the victims were taken to different hospitals around the area, generally 5 different hospitals. So at the beginning, we began by having detectives assigned to each hospital. Waukesha Memorial Hospital received the most patients, so they also had a lieutenant that was assigned there as a team leader. As the patients came in, they were identified by detectives. The hospitals also provided us with lists of patients that they had, and we went through those lists and tried to identify people that came in and were being treated.
And then eventually, were there follow-up interviews conducted with these individuals?
Yes,
tried.
there were.
What
We
if
would be
the
up and down
individual
all day.
was a person under the age of 18?
Objection leading.
Overruled. You may answer.
If the person was a minor under 18, then we would reach out to their parents, talk to the parents. Some of the kids weren't able to talk to us, but we got the majority of their statement from their parents.
Okay. And do you believe that the names on Exhibit 15 truly reflect all the injured victims that you were able to identify in the course of this investigation, sir?
Objection statement.
No, I do not.
Hold on. There's been an objection. It's overruled, and the witness will repeat his answer.
No, I do not.
Can you explain that?
Objection leading.
Overruled.
Just because of the scope of the investigation, we had so many people that were hurt. We had to come up with some kind of parameters to limit the people that we would call victims. One of those parameters is that they had to receive treatment at a hospital. Another one is that they had to be in the street when their injuries occurred. So there are some people that were injured, maybe on the sidewalk, trampled by the crowd, or received injuries that they didn't get hospital care from. You know, and unfortunately, I learned later on there's even a person that was in the band that somehow we missed her being reported that she received a broken leg. So there are some that are not on the map, but all the people that have been charged are on the map.
So you mentioned people on the sidewalk. We did have some spectators testify in the trial, correct?
Objection leading.
Overruled foundational.
Correct, but they were more in the roadway or on the curb, not on the sidewalk or not running away from the incident when it happened.
I see. So was, in your mind, when you were leading this investigation, trying to identify victims, what was the importance of the SUV in the injuries that were caused?
Objection leading.
Sustained as to the form of the question. Please rephrase.
Why were the spectators that are on this map included?
Because they were directly contacted by the SUV that came down the street.
If a person were injured because they were trampled by the crowd, are they on this map?
We exclude those.
Speculative.
Overruled, the detective may answer.
Those people were excluded from the map.
There were some people like that, right?
Yes, they
Objection
were.
leading.
Please make
Sorry.
sure. Thank you. I'll allow his answer to stand. Next question.
All right. I'd like to put up for you exhibit number 32, which has been previously identified. I'm sorry, admitted.
I'm sorry, you said 32? You said
Yes.
32? Okay, thank you. Sorry, I just missed it. Just to the witness or published because it's been received.
Yes, we are going to publish this, Your Honor.
Go ahead.
But I
Permission
do-
granted.
Okay, thank you. And while we're waiting for it to come up in the jury box,
I don't have it on my screen.
It may take a second. Hold on. If it's not, let's check the cables.
We don't have it
Yeah.
either.
I can see it. The witness can see it.
mhm.
Go out it. Thank you for letting us know, sir.
It's just the front tables, back tables on, Your Honor.
Hold on. Stop source for a second. I know. Anything? Yeah. You can see it on the screen though, right, sir? On the, there's screen, obviously, on the far side of the courtroom and then to your right.
It's always better on here because
I understand. We'll get our tech guy over here to look at it, but it's previously been received.
I think that's where I
and
step
we can
in.
see
They need the tech
two
guy. Yeah,
Other
I'm here
monitors.
for you.
So for now, we're going to continue. There's
Definitely
anything
their
new, I'll make
go-to
sure
guy
to
for all
pause.
technology needs,
Go ahead.
because you guys know I'm the king of
Detective
technology.
Casey, I want to focus your attention specifically as to the extreme dance team. We heard testimony about several of the girls on the team being struck and injured. Do you remember that testimony, sir?
Yes, I do.
Overruled, it's foundational.
What's up, Bella?
The answer may stand.
How's the arm going?
Do you know if there were other people associated with the extreme dance team that were injured?
objection speculative.
Overruled, he may answer.
Yes, I do.
And do you know the names of these people?
Objection hearsay.
Overruled, he may answer.
Yes, I do.
What were their names, please?
Kathleen Pellmeyer.
Speculation.
Overruled.
So they were actual real
He may
victims
answer.
that were hurt, and these are actual real names.
Go ahead, sir.
You
Kathleen
raging
Pellmeyer,
trash bag.
Jennifer Stover, and Mitchell Lampine.
What was their role with the dance team?
Go ahead.
Jennifer and Kathleen were support people. Jennifer's daughter was marching the parade. And then Mitchell was there to hand out candy with his stepmom.
Okay. I'm going to now play, it's still not being displayed on our tables, Your Honor, but it is displayed on the two large monitors in the courtroom. So do I have permission to proceed?
Which exhibit?
This is 32.
Oh, yes. If we get to a new one that hasn't previously been received, then
Yes,
I will
okay.
pause to get
All
the
right.
tech people in.
All right. And
Go ahead.
Objection
Bailiff.
as to relevancy.
Overruled.
The bailiff confirmed it's on in the jury box, Your Honor.
Thank you.
All right, please play. From the 32-second mark, I'm sorry, 35-second mark to 47 seconds.
How long is the exhibit?
Looks like it's a minute 23 according to what I can see on my monitor.
Definitely.
It is 123 total. We're only playing this 12-second clip from 35 to 47.
Thank you.
And please pause. Do you see any of the individuals you were just testifying about enter the screen, sir?
Objection speculative.
Overruled. He may answer.
Yes, I do.
Could you identify them by using the touch screen?
Objection leading.
Overruled. He may answer.
I'm going to draw one big circle.
Okay,
It has two individuals. It has Jennifer and Kathleen. Kathleen has the red jacket on, and directly to her left would be Jennifer in the black jacket.
okay. A little hard to see right now, but as
Yeah,
they,
very hard to see.
as they
Keep going.
walk, could you see two people walking there, sir?
Yes, ma'am.
Okay. Please clear the screen and continue playing. And pause. And I'm sorry, because I can't see the counter, Your Honor.
It is at 44 seconds.
44 seconds. Thank you. Paused at 44. Do you see anybody else that you just testified to in the video at this point, sir?
Objection speculation.
Overruled. He may answer.
Yes, I do.
And who is that?
Leading.
Mitchell,
Objection.
Overruled.
Mitchell Lampine.
Please circle Mitchell. Do you know Mitchell's approximate age?
Objection speculative.
Overruled.
I believe he's about 10.
Okay. All right, we can take down 32. Did this video goes on to show the red SUV drive through the extreme dance team, correct?
Objection leading.
Foundational. Your Honor.
Overruled. It's foundational. It's previously been received. Go ahead.
Yes, it does.
To your knowledge of this video, sir, did those individuals, Mitchell and Ms. Stover and Ms. Pellmeyer, remain along the left side of the road there as the SUV went through?
Objection leading.
Overruled. The witness may answer.
They were hit by the vehicle and then moved to the left.
Let's take a pause for a second. We
Yes.
have our IT experts. Hopefully I can get this figured out.
A lot of pressure.
Go ahead.
Could you put something on the screen that's okay with you for a moment?
Next one will be 132 if you want. No, I'm sorry, 55.
It's on our screen.
It's on now.
Hold on, let's make sure. Do you have it now, sir? Yes?
Yes.
Oh, good, great. It's on mine, it's on the witness. All right.
Just
Thank
like
you.
real life. You call the help desk and they show up and now it works. Yeah.
Jury monitors were working. It's not, hold on, let's make sure. It was just working. There's a delay. It can take 30 seconds.
What exhibit is this one?
This is 55.
All right, it's on. Very good. We're up and working. And 55 has previously been received, so go ahead.
All right.
Objection to the relevancy of 55.
Noted, overruled. Go ahead, Attorney Alper.
Detective Casey, Exhibit 55. Can you see at the end of the road there or the top of the screen what unit is involved in Exhibit 55, please?
Yes.
Please tell us.
Objection leading.
Overruled.
It is the dancing grannies that are approaching from the right.
Okay. And one of the dancers, we have her testimony that was involved with the grannies was a woman by the name of Lola Hospel. Is that correct?
Objection leading.
Overruled. It's foundational. The witness may answer.
Yes, she was.
Is there video showing Miss Hospel being struck by the SUV?
Objection leading.
Sustained as to the form of the question. Please rephrase.
Sure. Is exhibit, you've seen exhibit 55 before?
Yes, I have.
Are you able to identify Miss Hospel, yes, Lola Hospel in exhibit 55, sir?
Objection leading.
Overruled.
Yes, I am.
All right. We're going to play the clip, Your Honor, from from 4 seconds to 8 seconds at 50% speed. And it is zoomed in on the middle of the road where the dancing grannies are located.
All right, go ahead. Thank you.
Please describe for the jury what you just saw in the video, sir.
Objection leading.
Overruled.
I saw the red SUV driving westbound on Main Street, approaching the dancing grannies and hitting Lola Hospel and then striking 2 other dancing grannies.
When you say hitting Lola Hospel, what did you see?
Objection leading.
Overruled. You may answer.
I saw the left side of the car come in contact with her, and then her body moved to her left after.
Did Ms. Hospel report any injuries to the Waukesha Police Department?
Objection leading.
Overruled. The witness may answer.
Yes, she did.
All right, sir. I'd like to now ask that Exhibit 118 be published for the jury. This has previously been admitted.
Permission granted.
Objection to the relevancy of 118.
It's previously been received. Go ahead.
Sir, do you recognize the item shown in Exhibit 118?
Yes, I do.
And in addition to the photograph, have you had an opportunity to examine that item or items
Objection leading.
personally?
Overruled. The witness may answer.
Yes, I have.
And Mr. Johnson from the crime lab testified about these items yesterday, but I'd like you to tell the jury what you remember of these items, please.
Objection leading. Formative. The first part of the question.
Overruled. The witness may answer.
So this is the red SUV that was used in the parade attack. This is a picture of it taken after. I remember a hood from a white jacket and a hat, a black hat with snowflakes on it, being pressed in between the hood and the windshield wiper of the vehicle.
Objection to it being called an attack. I think that's a disparaging remark for the record.
I mean,
Your
one that doesn't
objection
sound good about the
is
thing that you did.
Noted. And the answer will stand.
He doesn't like the fact that it's being called an
I
attack.
will instruct the witness to
Let's call it an
simply
accident or
describe
something.
what
Like,
he is seeing without further characterizing it, as it will be up to the jury to determine.
funny when he
the facts in this
chooses to
case. Go
chime
ahead.
in, you know what I mean, about what he feels, because he's going to try to
When
play
you
that.
saw
like it
these
wasn't
items
him, so
on the
why would he care if it
hood
was
of the
considered
red
an attack?
SUV,
You know?
did you later come to recognize where they may have come from?
Objection leading.
Overruled. The witness may answer.
Yes, I did.
What did you determine?
I determined that they were the jacket, hood, and hat that Virginia Sorenson was wearing while she was walking in the parade.
Like to display to the witness only, please, Exhibit 177. This has not yet been received, Your Honor.
All right, go ahead, please.
Is 177 on your screen, sir?
Yes, it is.
And what do you see in Exhibit 177?
Objection leading.
Overruled.
I see two dancing grannies carrying a Milwaukee dancing granny sign, and the woman on the left is Virginia Sorenson, and she's wearing a black hat with snowflakes, wearing a white jacket with a hood on it.
Move to admit 177 and permission to publish, Your Honor.
Objection to relevancy.
The objection is overruled. Exhibit 177 is received. Permission to publish is granted.
Said 177?
177, yes. Go ahead. And if the jurors will let me know when it's in the jury box as well, please. All right, thank you. It's there.
And again, just so we're clear on the record, please circle Virginia Sorenson in the hat in this picture.
Objection leading.
Overruled.
That is Virginia, and then this would be the hat and hood that I believe was found on the SUV.
Detective Casey, there were many videos that have been shown to this jury, correct?
Objection leading.
It's foundational, Your Honor.
Overruled. The witness may answer.
Yes, there has been.
To your knowledge, are there any videos that display the license plate of the red SUV as it goes along the parade route?
Objection leading.
Overruled.
Yes, there are.
Is it possible to capture a screenshot from those videos to see the license plate of the red SUV along the parade route?
Yes, there are.
I'd like to display for the witness only, Exhibit 150.
Go ahead.
Is 150 on your screen, Detective?
Not yet.
Okay.
It is now.
All right. Do you see Exhibit 150?
Yes, I do.
Please describe what you see in Exhibit 150.
Objection leading.
Overruled.
I see the red SUV that was driven through the parade route, and it's at the time when it was contacting the Waukesha South band members. In that photo, you can read the license plate number.
Do you believe this photo is a true and accurate representation of the events of the day?
Yes, I do.
Move to admit 150 and permission to publish.
Objection. How does this go to investigation? Exhibits
Overruled.
on investigation.
Exhibit 150 is received. Permission to publish is granted.
The image is a little blurry, correct?
A tad.
Can you please point out the license plates in the photo and read it for the jury?
Is it okay if I circle it?
Yes.
Overruled. You may do so.
That is the license plate number, and I read ADP 9256.
All right. Now I'd like to show to the witness only number 151, please.
Go ahead.
Please describe 151. Oh, please clear the screen, Madam Clerk.
This photo is of the red SUV on the parade route. It's just photo taken just prior to the Barris Logistics float. And the band director is in the lower left-hand side of the video. It shows the red SUV with the license plate number displayed.
Do you believe this photo represents a true and accurate depiction of the events of the day?
Yes, I do.
Move to admit 151 and permission to publish, Your Honor.
Objection to relevancy.
Exhibit 151 is received, permission to publish granted, the objections noted and overruled.
I recall this station, we had 140 exhibits. How did we get this many?
Keep going, Attorney Upper.
Detective, please describe what you see in 151. I think you did describe it. Strike that. Please circle the license plate and read it for the jury.
Objection leading.
Overruled.
ADP 9256.
Thank you. It's still not up. Okay, I'm sorry. Gotta wait for the jury. Go ahead. Detective Casey, during your investigation, did you uncover any other videos linking Mr. Brooks to this same vehicle with this same license plate?
Objection, I don't consent to being called their name and is leading the witness.
Overruled as to both counts. You may answer.
Yes, we have.
Could you describe this video for us, please?
Objection leading.
Overruled.
There's a video that we obtained from social media that shows Mr. Brooks standing next to the SUV, and you can clearly see the license plate number on the vehicle. I believe the video was taken sometime prior to November 21st, 2021.
Okay, I'd like to display for the witness only Exhibit 175, please.
Go ahead.
Please identify 175.
This is
Objection. Relevancy.
Overruled. You may answer.
This is a photo. There's two individuals in the photo. The individual on the left, I know to be the person referred to as Darrell Brooks. It displays a vehicle, a red Ford, and it has the license plate number, which is displayed in the photo.
What is the source of this photo?
Objection leading.
Overruled. The witness may answer.
We obtained it through social media.
Okay. I mean, this is a photo versus a video.
This is the photo taken from
Hold
a
on.
video.
I understand the objection. It's sustained. It's foundational. This particular question, the witness may answer. Go ahead.
This is
Overruled or sustain?
Overruled.
He said sustain.
What did I say?
Yes, you did.
Sorry. I meant it's overruled. The witness may answer. Sorry. I'm taking notes. I was writing the word source, and I think that's why I did that. In any event, go ahead and answer. Sorry about that for any confusion I may have caused.
This is a screenshot taken from a video.
Move to admit 175 and permission to publish, Your Honor.
Objection to that. What's the relevancy? I don't see the alleged defendant in here.
Your objection is noted. It is overruled, and Exhibit 175 is received. Permission to publish is granted.
Sorry.
The jury would also let me know when it's in the jury box monitors or on the jury box monitors. All right, go ahead.
Detective Casey, is person you know as Darrell Brooks in this photograph?
Objection, I don't consent to being called their name and leading the witness.
Overruled. The witness may answer.
Yes, he is.
Please circle or X or mark in some fashion. How do you know that's Darrell Brooks there? His back is to us.
Objection leading.
Overruled.
I've watched the video in its entirety, and I've seen his face in the video.
Okay, that can go down, please. Detective Casey, in total, how many videos do you think were collected by the Waukesha Police Department during this investigation?
Objection, speculative.
Overruled. You may answer.
We have at least 65 to 75 files. Some of those files contain multiple videos, photos, could be 10 each. So I would say probably 300 to 400 videos we've collected.
What were the source of those videos?
Some of the videos came from different people that were at the parade. Some of them are from city-owned cameras, and some of them are from fixed surveillance systems from businesses that were in downtown Waukesha.
Were all of the videos that were available shown to this jury?
No, they were not.
Objection, leading.
Overruled. You may answer.
No, they were not.
Have you personally observed and reviewed each of the video files available in this case, sir?
Objection, speculative.
Overruled. You may answer.
Yes, I have.
To your knowledge, sir, did any video ever show a different person behind the driver's wheel of that red SUV?
Objection, leading.
Overruled. The witness may answer.
I have never seen anyone driving the vehicle besides the defendant in any of the videos that I looked at.
In any of the videos, were you ever able to see multiple people inside the vehicle?
Objection, speculative.
Overruled. The witness may answer.
None of the videos that we have looked at showed anyone else in the vehicle.
Do any of the videos at any point show the red SUV coming to a stop, a complete stop along the parade route?
Objection, leading is speculative.
Overruled. The witness may answer.
I've never seen a video that shows the vehicle slowing or stopping while it was on the parade route.
Do any of the videos show the driver of the vehicle exit the vehicle to check on a person who had just been struck by the vehicle?
Objection, leading.
Overruled. The witness may answer.
I never observed in the videos the driver of the vehicle to stop and check or exit the vehicle on anyone.
There was testimony earlier in this case about witnesses observing multiple people running from the car. Do you remember that?
Objection, leading.
Overruled. The witness may answer.
Yes, I remember that.
Were there multiple reports like that, sir?
Initially, there were some reports like that.
When the vehicle was found on Maple Street, you weren't there.
Correct.
Objection, leading.
Overruled. His answer may stand.
Do you know what police activity occurred when the vehicle was found on Maple?
Objection, speculative. Just stated he wasn't there.
Overruled. The witness may answer. He was asked, what does he know?
Yes, I do.
Please tell the jury what happened when the SUV was found on Maple.
Objection, leading.
Overruled. The witness may answer.
Initially, Officer Moss went, he secured the vehicle, did not find anybody in the vehicle. There was an initial report that saw some other people running from the area of the vehicle. After that information was given back to us, we sent detectives down to the area to investigate further to see if we could corroborate and find out if that was true or not.
After that investigation, did you have other suspects or just one person?
Objection, leading.
Overruled. The witness may answer.
Based on the information of what everybody saw on the parade route, and then the detectives that went back down to Maple Avenue where it interviewed the people that reported the people running, our investigation determined that there was only one person in the vehicle and there was no other suspects that we were looking for.
At some point in your investigation, Detective Casey, were you given a Ford key?
Objection, leading.
Overruled. The witness may answer.
Yes, I was.
What was your understanding as to the source of that key?
My understanding that that key was taken from Mr. Brooks when he was taken into custody and turned over to Detective Stern and Detective Carpenter.
Objection, I don't consent to being called that name for the record.
Noted. Overruled.
How did you get it?
Objection, leading.
Overruled. The witness may answer.
You just stated how you got it.
Overruled. He may answer.
Detective Stern brought me the key the morning after the incident.
Did you do anything with the key?
Yes, I did.
Tell the jury what you did, please.
Objection, leading.
Overruled.
At that point, the vehicle was at the Waukesha County Sheriff's Department secure storage facility. Mr. Johnson was over there processing the vehicle. I went there and I took the key with me and I checked the vehicle to see if the key would work in the car.
What did you find?
Objection, leading.
Overruled.
I found that the key worked the door locks to unlock the car. I also put the key in the ignition and it turned the ignition lock.
Thank you. Detective Casey, you've heard testimony about the manner in which the defendant was identified by the name of Darrell Brooks. Do you recall that testimony, sir?
Objection, I don't consent to being called that name. He's leading the witness.
Overruled. Foundational. The witness may answer.
Yes, I do.
Did you endeavor to verify the identification of the subject you had arrested for this incident?
Objection, leading.
Overruled.
Yes, I have.
Did you verify his identity by the name of Darrell Brooks?
Objection, I don't consent to being called that name. Leading.
Overruled. The witness may answer.
Yes, I have.
How did you do that?
Objection, leading.
Overruled.
There were a couple different ways. One way is when a person is taken into custody, we take their fingerprints. We check that against other records that are kept by the state. Those fingerprints matched Darrell Brooks. I've also spoken to 3 women that he has children with. They verify that is his name that he has always gone by. I have also spoken to his mother, which states that that's the name that he has gone by always.
I'd like to put on the screen for the witness only Exhibit 88.
Go ahead.
Do you see Exhibit 88, sir?
Yes, I do.
Objection to this. What's the relevancy?
Overruled. Go ahead.
Grounds for the overrule.
Relevant.
In what way is it relevant?
To the counts alleged in this case. Go ahead.
Can you please identify Exhibit 88, sir?
This is a bail bond through Milwaukee County Circuit Court for Darrell Edward Brooks, the date of birth of 2/21/82.
To your knowledge, was Mr. Brooks on bail through a Milwaukee County case on the date of November 21, 2021?
Objection, leading.
Overruled. The witness may answer.
Yes, he was.
And what is the date of this bail form, please? I believe it's near the bottom.
The date on the bottom
Objection,
is
leading.
Overruled. The witness may answer.
2/21 of 2021.
Was we'll strike that. By classification, can you tell us the level of charges that Mr. Brooks was pending on for this bail?
Objection. You've already made a ruling on it.
Overruled. The witness may answer.
All the charges that I see in here are felonies.
To your knowledge, was this bail in full force and effect on November 21 of 2021, sir?
Objection.
Overruled. You may answer.
Yes, it was.
And in the middle of the form, do you see the conditions of bail that were set upon Mr. Brooks?
Objection, leading.
Overruled.
Yes, I do.
And I'm looking under paragraph B, the third bullet. Do you see that?
Yes, I do.
Could you please read that bail condition to the jury?
Objection, leading.
Overruled. The witness may answer.
The state defendant shall not commit any crime.
Thank you. Move to admit number 88, Your Honor.
Objection.
Exhibit 88 is received.
I'd like to display for
It was
the,
already speculated to. How's that coming into evidence?
Overruled. And permission to publish.
I'm sorry, I did not seek to publish this, Your
Oh,
Honor.
all right. Turn that
I
on.
request a legal finding of fact for that.
The objection is noted. It's overruled. Continue. Attorney Opper.
Thank you. I'd like to display for the witness only exhibit 89.
Go ahead.
Sir, can you please identify 89?
Objection.
Overruled.
Relevancy.
Overruled.
This is
This has been speculated, stipulated to as well. How's it evidence? How's it being admitted?
The objection's noted. It's overruled. The witness may answer.
I request a legal finding of fact for that too, Your Honor.
Noted. Overruled. Go ahead.
To be clear, when I go to the supporter chat,
bail bonds from
it won't stop you
Waukesha
from
Circuit
viewing
Court
here.
for Darrell Edward Brooks,
At
date
all.
of birth of 2/21 of 1982.
We just
Is this a
provide
different
that
case
as
than
a
what was
perk to
displayed
our
in exhibit
supporters,
88?
where they have an exclusive time to chat. You can still view just like you are right
overruled.
now,
Yes,
but
it
it
is.
provides a breakout opportunity for
Are you
chat
able
with
to
the
make any
supporters.
observations about the level of charges related to this case, sir?
Objection, leading.
Overruled.
It appears that there's 4 charges, 2 of which are felonies.
Okay. And on the bottom of the form, can you tell the date that this bail was issued?
Objection, leading.
Overruled.
States 11/11 of 2021.
The directing your attention again to that same location in the middle of the page under paragraph B, the third bullet. Could you please read the conditions of release that were set by the court in that case?
Objection, leading.
Overruled. The witness may answer.
Defendant shall not commit any crime.
To your knowledge, sir, was this bail in full force and effect on November 21 of 21?
Objection, speculative and leading.
Overruled as to both. The witness may answer.
Yes, it was.
Finally, sir, I'd like to put up one last item for you, or 2 items. 1 second, please. I'd like to display for the witness only exhibit 13.
Objection, what's the relevancy of this? How does it say any foundation to testimony?
I'll give the state some leeway to establish that. Go ahead.
Thank you. Sir, do you recognize can you tell if exhibit 13 is a video, sir?
Yes, it is.
Okay. Have you seen this video before, sir?
Objection, leading.
Overruled.
Still relevancy.
Um,
Where's the relevancy?
The state is asking the foundational questions. The objection's a bit premature. I'll take it under advisement. Go ahead, Attorney Opper.
Yes, I have.
What does this video depict?
Objection leading.
Overruled. The witness may answer.
Objection speculative.
Overruled. Go ahead.
This video depicts the backyard at 4014 North 19th Street in the city of Milwaukee. It also, that's the address of Dawn Woods, the mother of Darrell Brooks. And on the lower left-hand corner, you can see a Ford Escape.
In the lower
Objection.
right,
I move to strike that. How does he know? What?
The objection's noted. Overruled. You can ask him on cross-examination. You can question him about that. Go ahead.
in the bottom right-hand corner of the exhibit, do you see a date and time stamp for this video, sir?
Objection leading.
Overruled.
Yes, I do.
What does it say?
It says 11/21-2021, and then it says 13:26:18.
What do those numbers represent, sir?
Objection leading.
Overruled.
To me, it'd mean that the video was taken on November 21st, 2021 at 1:26 p.m.
And do you believe this video is a true and accurate representation of the events of that afternoon at that location, sir?
Objection speculative.
Sustained, if you could lay a little more foundation.
Sure.
please.
How did you come into possession of this video, sir?
The defendant's mother provided it to us.
And do you know approximately when it was obtained?
Objection speculative.
Overruled.
The evening of November 21st, 2021.
Do you know if the defendant's mother was cooperative with police in providing the video?
Objection relevancy.
Overruled. The witness may answer.
Yes, she was.
Do you know if the video was provided to police when asked?
Objection leading.
Overruled.
Yes, it was.
Do you have any reason to believe that the video was altered or modified in any way before it was provided to police?
I do not.
Move to admit 13, Your Honor, and permission to publish.
Objection. Relevancy.
Noted. Overruled. Exhibit 13 is received. Permission to publish is granted.
For the record, this is a video. It's 49 seconds in duration. We're going to play it in full. There is no audio, and it will be played at normal speed. Oh, hang on. Don't play yet.
Yes, if the jurors would let me know when the monitors are displaying the video. All right, go ahead.
Detective Casey, were you able to see any emblem on the front grille of that vehicle as it drove away?
I would have to look at it again.
Okay, I'm sorry. Let me ask you this. Did you see any damage to the front end of that vehicle as it drove away?
Objection leading.
Overruled.
I did not.
Okay. I'm going to put up State's Exhibit 14 now, please.
Go ahead. Just to the,
Yeah, just to the witness only, please.
thank you.
Do you recognize Exhibit 14, sir?
Yes, I do.
What is the source of Exhibit 14?
This is a still shot taken from the video.
The same video we just saw, number 13.
Yes.
Move to admit 14 and permission to publish, Your Honor.
Objection, relevancy.
The objection's overruled. Exhibit 14 is received. Permission to publish is granted.
Sir, do you see Darrell Brooks in this photograph?
Objection, I don't consent to being called that name again for the record.
Noted. Overruled.
Yes, I do.
Can you identify or, excuse me, describe the clothing items that you see him wearing in this photograph? Oh, it's not in the jury box yet. I'm sorry.
You can state your objection, though.
Leading.
Overruled. The witness may answer.
Mr. Brooks is wearing a red t-shirt, blue jeans, and he has blue colored flip-flops on with white socks.
And what's the date and time stamp for this photograph, please?
It's 11/21/2021 at 13:26:08 hours.
And that's what time, sir?
Objection, leading.
In, on the 12-hour clock.
Objection, leading.
Overruled.
That would be 1:26 p.m.
All right, thank you. I don't have any other questions, sir?
Lee Cross.
In the two exhibits we just watched, 13 and 14, do you see anyone driving a vehicle?
No, I do not.
Do you know if anyone's in the vehicle at the time that you see it pull away?
I would assume, based on my training experience, that when the vehicle pulled away, that there was someone inside the vehicle, because in order to move a vehicle, you have to manipulate the controls, the shifter, the brake, the accelerator. So my assumption is that someone is inside the vehicle doing that.
That wasn't the question. Do you see anyone in the vehicle?
I object, Your Honor, that was the question, and he's already asked and answered. The question is, anyone can be seen.
The objections. I'm not sure what the objection was, but the answer may stand. You can ask your next question.
Let's go back to exhibit 175 and pull that up for the witness.
Would the state please pull that up? Witness only or published?
Publish.
Okay, thank you. Go ahead. Jurors, let me know when it's in the jury box as well. All right, go ahead. It's in the jury
You
box.
just testified that this was the alleged defendant. How do you know that? Can you see a face?
Which question are you asking? Those were two.
Can you see the face on the circled individual in that exhibit?
In this clip, I cannot see the face of the person that is circled.
So how do you know who it is?
I can tell who that is because I have watched this video in its entirety, and I can tell that it is you based on all of my contacts with you.
So why were there not any other exhibits that can give credibility to you positively identifying the individual in this video?
Objection, argumentative,
Grounds.
compound.
Sustained as to the form of the question.
Is it fair to say that this is the only exhibit photo from the video?
Go
Can
ahead.
you clarify the only one that is shown today, or the only one that has ever been taken?
The only one that's
ever
the only
exists?
one that's
Could you clarify,
being
please?
shown right here today. Is this the only one that is an exhibit being shown here today?
Yes, this is the only one that we've shown today.
And you can tell just from this exhibit exactly who that individual is.
I don't believe that was my testimony.
I'm asking the question.
From just looking at this, no, but I know from looking at the entire video that it's you.
We're talking about this exhibit that's being shown right now during your testimony right now at this moment. Strictly that.
Could you ask your question, please?
I'm going to object, asked and answered.
Sustained as to the form of the question as well.
Would it be fair to say that from this exhibit 175 that they're looking at right now that you cannot tell who the circle individual is? Would that be fair to say?
That would be fair to say.
Can you clear the circle?
Thank you, Madam Clerk.
And do you recall what date you viewed this video, as you call it?
I have viewed this video multiple times. I don't recall the specific dates that I've seen it.
Was it relatively early on in the investigation?
There have been multiple times that I've watched this video. Some of them early, some of them as late as yesterday.
Do you recall seeing this video the same night of the incident or in the days following?
I did not see it the night of, but it would be the days following that I have seen it.
And at that time, did you have knowledge of who that vehicle belonged to?
Yes, I did.
And did you have knowledge of the usage of that video? I mean, the usage of that vehicle?
I'm not sure that I understand the question.
Did you have knowledge of who may have been using the vehicle?
Objection vague as to time.
Sustained as to the form of the question, if you could limit or perhaps direct him to a specific time frame regarding the use of the vehicle.
At the time of the incident?
Yes.
And what? And can you clear that? And what information was that?
The information that I had is at the night of the incident that you, Darrell Brooks, were the person that were operating the vehicle.
And who did you learn that from? And for the record, I don't consent to that name.
Noted,
For the record.
overruled. Go ahead and answer.
Can you repeat your question, please?
I'm gonna go another route on this.
You done with the exhibit, sir?
No, I'm not.
So you're withdrawing your question?
Yeah, I'm going another route.
All right, thank you.
You just testified to seeing the entire video that this steel frame exhibit came from, correct?
I testified that this came from the entire video, correct?
You said that you viewed the video in its entirety, correct?
The entirety, what we recovered from your social media account. I'm not sure if there is a longer version someplace, but.
Did you see the video in its entirety? The video that this exhibit came from?
Yes.
And are these the only two individuals that you observed in that video?
They are the only two that I recall seeing in the video.
Did you ever inquire about the identity of this individual?
No, I have not.
Can you clear that circle?
Thank you, Madam Clerk.
Would it be fair to say that from looking strictly at the exhibit that we're viewing right now, that both individuals have the same hairstyle?
It would be fair to say.
Can we clear the X's and clear the exhibit?
Go ahead. Thank you.
We go back to exhibit 13, published.
Go ahead. The state would assist, please.
13. Can you play it? Well, just play it. I'll tell you when to pause if that's okay.
Go ahead.
It's not up yet.
Oh, thank you. We're gonna wait until it's in the jury box.
Okay.
Okay, go ahead. Thank you. Just a reminder, it's 49 seconds long.
I don't think I'm gonna need the. Well, I don't know. Yeah, I might. Pause. Right there, the individual that you observe. Right here. Do you see them wearing a hoodie?
The person in that photo is not wearing a hoodie.
Do you see a hoodie anywhere present in this video?
So you took it
I
off,
don't see
man.
a
Big
video
deal.
or a hoodie anywhere in the video.
Couldn't be me then.
Take the X down.
Dean, I feel you. I'm glad that there aren't any fires that need to be
From
put
this
out. You know what I
angle,
mean?
it'd be fair to say that you can see the very front end of a vehicle, correct?
That is correct.
Can you see any windows or see inside the vehicle at that time? Or at the time that we're looking at right now?
You cannot see inside the vehicle at this time.
So it would be fair to say that just by looking at what we're looking at now, you wouldn't know if anyone's already inside the vehicle.
This has been asked and answered, Your Honor.
I'll allow it. The witness may answer.
This is a whole different.
I'm allowing it. Go ahead.
That is correct. From this video, you cannot tell if anyone else is inside the vehicle.
So it'd be fair to say that you're not sure.
It's fair to say that I am not sure.
Can we pull this down? Whoa, wait. I'm sorry. Can you pull that back up for 1 second?
Same exhibit.
Same
Go
exhibit, 13.
All right. The state would put that back
Right.
on display,
It does-
and there you go.
The-
Do you want any
Wait.
more of a plate or just the still?
We waiting for the jury or do they?
It's up.
No, we don't need it played.
Do you need it to go to a certain point?
Yes,
All right. Do you know what point?
I'm about to do it right now. Looking at this house right here, do you see an address posted anywhere on this house?
In the photo that you circled, no.
So it'd be fair to say that you don't know the address of this house.
That is incorrect.
You just said that you don't see an address posted anywhere in this house. So from the vehicle, strike that, not the vehicle. I'm still looking in the corner right here. From the video that we're viewing right now, do you see an address posted anywhere on this house?
I do not see an address posted in this photo.
So judging by this, well, actually it's a video, but judging by this video, how can you know the address of this house?
Because I've been at this house before to talk with your mother, I've seen the address on the front of the house.
Judging by this video.
Hold on, you have to let him finish because that was not the question you asked. You asked him how he knew. He can answer. Go ahead, Detective Casey.
I've been at this address before. I've spoken to your mother. I've been in the backyard of the residence. I've seen the address on the front of the house. I know this to be your mother's house. I recognize from this photo to be your mother's address at 4014 North 19th Street.
You recognize the house or the address? Because we don't see an address in this video.
I recognize this house to be that address from being there.
And had you already been there, as you say, and talked to people, as you say, before you viewed this video?
I believe that I saw the video first, and then I was at the address.
So at the time that you saw this video, you didn't know whose house that was?
That would be an incorrect statement.
You just said that you saw the video first before going to the house. Did you, or did you not say that? That'd be fair to say.
I guess I'm a little confused in your question. We received the video. We know from getting it from my mother's that she said that that is where she lives. So I knew that this was where she lives when I watched the video. That was clarified for you.
I follow you, but that clarification wasn't stated before. So that's fair from the clarification.
So he's trying to lead him into giving an answer that he's not going to give you, buddy.
This exhibit?
Yeah, you're not getting what you want out of it, man. That's just all there is to it. You know what I mean?
Yeah.
All right, you take it down. Thank you.
You made reference to a key being found. Did you yourself find that key?
Definitely share the stream, guys.
Did you?
I mean, we got a lot to look forward to today.
Where the key was found at the time it was found?
No, I was not.
So it'd be fair to say that you were told that a key was found.
Yes, I was told that a key was found.
So it'd be fair to say that you went off of what you were told. You actually didn't observe this with your own eyes.
What are you speaking of?
The key being found.
That's correct. I was told by two officers who I've worked with for a long time, and I trust what they tell me to be accurate.
Because that's their sworn job. Yeah. But was there actually even a key? Maybe that key was made.
You made reference to
door.
There being a couple, was the
that.
word you used, a couple ways to identify individuals. And you stated that you had spoken with the mothers of the alleged defendant's children. That'd be fair to say?
I believe I said I spoke with the mother of 3 of your children.
At that time, was the alleged defendant already in custody?
Your children.
Yes, he was.
Wouldn't it have been easier to just use the fingerprints that were already obtained?
Like I said before, the fingerprints
Easy
was
to throw.
one way. We also verified it talking to his family members that his identity.
Any reason why, or let me back up. Is it fair to say that there was more confirmation needed to identify the alleged defendant at that point, seeing as how the fingerprints were already obtained?
We were just being thorough. We were certain that it was Darrell Brooks that we had in custody based on his fingerprints and other information that we had. It was just a matter of being thorough and verifying the person that we had and the name that he goes by.
It'd be fair to say fingerprints are pretty accurate, though, correct? Would that be fair to say?
I think that would be fair to say.
So it would also be fair to say that there wouldn't be any reason why the alleged defendant that was in custody would be someone else. Wouldn't that be fair to say?
Objection, that's compound and difficult to follow.
It's not compound. It's
Sustained
not
as to the
difficult to
form
follow.
of the question, sir. Please
That was
rephrase.
very clear.
Sustained as to the form of the question.
And where did the interviewing of the mothers of these children take place, if you recall?
I spoke to Jessica Macklin in Iowa at her residence. I spoke to Angel Fitzpatrick at her residence in Menominee Falls.
Whoa. Can we strike that? Why do the names have to be stated?
Overruled, he was answering the question. His answer may stand, your request to strike is denied, and the witness may continue answering.
I spoke to Angel Fitzpatrick in Menominee Falls at her residence, and I spoke to Erica Patterson a number of times at various locations about you.
You said one of the mothers of these children you spoke to in Iowa.
Correct.
Why would you go all the way to Iowa?
Because initially you listed her as a witness on your witness list for court. So we went there and we wanted to verify what information she might have that she would testify to.
Just for the record, I don't recall listing anyone as a witness, just for the record.
For the record, Mr. Brooks, you can't testify at this moment. You'll have an opportunity should you choose.
I just wanted that clear for the record since what was
Can't be,
said.
it's struck from the record at this point because you're attempting to testify. The
Not
jury will
attempting to
disregard
testify.
that.
I just wanted the record to show
The
that I
jury
had no
will
knowledge of doing that. And if
The jury will disregard those statements made by the defendant as
something's-
he is not testifying, and it would be improper at this time for the court to receive them.
I don't think a
Go-
record should be
next
made of
question, sir.
something that I didn't do.
Next question, sir.
It's ridiculous. So you said you went to Iowa to try to find out what would be testified to. Why?
Objection, argumentative,
Grounds.
irrelevant, and calls for hearsay.
Grounds.
Sustained as to all basis. Next question.
Was that an attempt to prepare for what might have been said?
I'll allow that.
Okay.
Go ahead.
Yes.
Why would there be preparation involved in someone who might testify on an alleged defendant's behalf?
Objection, argumentative.
Grounds.
Overruled, I'll allow it.
We went there to speak with her, so if she came and testified, there wouldn't be any surprises. We also wanted to find out if there's any background information that she had about Mr. Brooks that would be helpful in our investigation.
So you made reference to not being any surprises. Would it be fair to say that there was a little worry there?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
What surprises were you referring to? What do you mean by surprises? No surprises.
Your Honor, I object to this entire line of questioning. This witness is not expected to testify. It's wholly irrelevant.
Well, he opened the door by putting the name on the record and saying where he went.
I will allow one more question on this. Go ahead, you may answer.
Could you re-ask the question, please?
What do you mean by making sure that there were no surprises?
We wanted to make sure that there wasn't any information that we weren't aware of that may come up later that would be helpful in the trial.
Do you recall making an attempt to interview the child
Objection, relevance.
who was 7 at the time?
Sustained. Next question, please.
Reason for the sustain, Your Honor?
Not relevant.
Well, the question was asked, does he recall?
Sustained. Next question, please.
Grounds for the sustain again?
Relevant.
How's it not relevant?
Keep going, sir.
Did you interview the child?
When is she going to say
Same
because
objection.
I say so?
Grounds,
Sustained.
Grounds for sustain.
grounds for the sustain?
Relevance.
Grounds for relevance.
Why would you ask to interview the child?
Your Honor, objection. This
Sustained.
entire line of questioning is inappropriate.
Sustained. Move on.
I would
Mr. Brooks.
object that.
Drop the mommy hammer.
Trying to interview a
10966.
7-year-old child is
Forget it. What is it?
Sir, move on, please. 90611.
90611.
It's also
Thank you.
not
There we go.
relevant.
90611.
Assumes
Very
that's not
relevant.
an evidence.
It was a tricky move.
Oh, guys. See, even she just is
You
like,
made
what
reference to
do I even do here? You know, what do you think she should do? How should
in
the judge
regards
handle
to
it?
Exhibit 88 and 89, which were documents from an entirely different county. Do you work for Milwaukee County?
I think
No,
she
I
does
do
hear
not.
you, Jess. Yeah, he doesn't care about his kids. Mind you, one of his children came from a 15-year-old girl that he raped back in 2006, that he was pimping
So how did Milwaukee County,
in Las
which is a
Vegas.
different county, come
I'll
into
forget that.
your investigation in Waukesha County?
Yes, he did. He did say
May I
it's a
answer?
tricky move.
With the understanding there are some limited.
Karen, thank you. Yeah,
Pretrial rulings that still are
906.11.
in
If you guys
play.
want to check that out, it's
Go
in the
ahead.
comments on Facebook.
During the
I was
normal,
I'm sorry for
At
interrupting. I started off by saying in regards to Exhibit 88 and 89. That's how I started the question, just for the record.
I know. I'm reminding the witness of the pretrial rulings.
Okay.
We got one of the mods go ahead and post that in YouTube. That'd be great. That this comment from Karen.
during the normal
I know what she's
course
talking
of
about.
an investigation, we do background on a person to see if they have any open cases or any information that would be helpful.
Drop people's
There
elbow.
is a computer system that displays what cases or charges are open for a person, and it is relevant because if you are charged in one county and you violate conditions of bail, you can also be charged in another county for those violations.
And in reference to having charges in one county and potentially being charged in another county, in reference to that, wouldn't you essentially have to violate the conditions in one county and strictly be charged in that county?
That is an inaccurate statement.
You being in law enforcement for a very long time, it would be fair to say that you're familiar with the term double jeopardy, right?
I've heard the term before.
And what is your understanding of what that term means?
Objection, irrelevant, beyond the
Grounds.
scope of the witness's knowledge, legal conclusion.
Sustained for all those reasons.
So when did you become the lead investigator in this matter?
That was about 8:30 p.m. on November 21st, 2021.
So same night.
Correct.
And whom were you made lead investigator by?
The command staff or Lieutenant Jerry Habonic.
Do you recall why you were tapped to be the lead investigator?
Because I was the most qualified person and had the most experience to take care of it. That's what I've been told.
Any other reasons besides that?
Also, because I was at the parade route a little bit earlier and I had the most information out of anyone. It took a little while for the other staff to come in. So I already had a little bit of a head start with the information that I already had learned as being there at the beginning.
And that would be in the information that you said you had more knowledge of than anyone else at that time. Would that be in reference to having an interaction with the vehicle at some point?
I would say as a totality of the situation, I was there when the car first went through. I know what the radio traffic was for taking Mr. Brooks into custody. There's also some decisions that were made early on how to proceed with the case. I was also on scene downtown and took control of the crime scene initially. So a lot of those decisions were made even before our command staff started coming in to take over lead on the case.
You referenced you were there at the beginning when the vehicle first entered in the parade. What do you recall about when the vehicle first entered the parade?
I remember a horn beeping, red Ford Escape driving around, and then you driving into me and not stopping when I pounded on your hood and window.
Driving into you, what do you mean?
I meant that I was in front of your vehicle contacted me, pushed me off to the side, and continued driving without stopping.
Were you injured in this incident?
I was not injured, thankfully.
And you made reference to a horn beeping. What do you mean a horn beeping?
I mean,
the vehicle was beeping its horn?
Yes, the vehicle was beeping its horn.
What would be the only time a vehicle would beep their horn?
Objection, speculation.
Grounds.
Sustained. Calls for
Reason.
speculation.
Do you know why the vehicle was beeping their horn?
Same objection, Your Honor.
Do you know why you would beep
He
your
asked,
horn?
do you know why? So he can answer that question.
Could you repeat the question, please?
Do you know why the vehicle was beeping its horn?
I imagine that the driver was angry and wanted to get through the crowd.
Or I don't know.
How did you
I can't get into the head of a.
Uh,
like you, bud.
I've been driving a long time, and a lot of times people get angry, they're late, they beat their horn at you in a way that is because they're upset and they're trying to get past you.
Do you know that for sure?
You asked me my opinion.
Yes, I did ask your opinion. Now I'm asking you, do you know for sure if the driver of the vehicle you observed was in fact angry?
I assume that he was.
So it would be fair to say you don't know for sure.
I do not know for sure, but that is my opinion, is that he was angry.
And at that time, you had no knowledge who the driver was. Would that be fair to say?
Well, I had knowledge because I saw your face. I did not know your name.
Did you
at that
know
time.
who the driver was? No, meaning had you had any prior interactions with them before this incident? That's what I mean by no. Have you had any conversations with him, talked to him?
Hold on.
saw him?
Compound question. Ask one.
I was just giving clarification of no.
You
What I
need to-
meant by
It's
no.
a compound question. Please rephrase.
Before you observed this vehicle, as you say, and this driver that, as you say, did you know them?
I have no memory of meeting Mr. Brooks before that afternoon.
So it'd be fair to say that you're assuming something that you don't know. Would that be fair to say?
Objection, compound, vague, and argumentative.
Sustained.
Grounds.
Sustained is to the form of the question.
How would you know how someone's feeling if you don't know who they are?
Your Honor, he opened the door to this. It's asked and answered. The witness has given his opinion. It's clear.
Grounds.
I object. Improper question.
Grounds.
I will allow the witness to answer why he came to that conclusion. Go ahead.
Like I said before, I've been driving a long time, and a lot of times when people are beeping their horns, it's because they're late, they're angry at something happened, and that's why I concluded that the person was probably angry.
So would it be fair to say that another reason why a vehicle would beep its horn would be to alert people to the presence?
Objection.
Grounds.
Irrelevant speculation.
Grounds.
I'll allow it. Based
Irrelevant
upon his
and
training and
speculation.
experience, he may answer.
It's a possibility.
And did you hear this beeping before the vehicle approached you?
Yes, I did.
He's trying to avoid the intentional homicide because he's trying to say, I honked my horn. I wasn't trying to run you over. I wasn't trying to kill you. I beeped my horn at you, trying to ask you to get out of the way. You know, I gave you fair warning that I was coming. Watch.
It made reference to,
which is still going to put him down to reckless
and I'm
homicide,
referring to,
which has a 35-year penalty for each.
The ring video obtained.
Good luck on the 180 plus years on that one.
88, or I'm sorry. The ring video obtained in exhibits 13 and 14. You made reference to obtaining that the same night of the incident. Do you recall saying that?
Yes, I recall saying that.
And it would be fair to say that you yourself have been present for all testimony. Would that be fair to say?
That is not correct.
How so?
I was sick one day and I was not here.
Well, I'm referring to, let me clarify. Maybe I wasn't clear enough. Pertaining to all testimony since trial began, you've been present for all testimony. Would that be fair to say?
I believe I've seen most of it.
Do you recall testimony of and I'm referring to, again, so clear for the record, exhibits 13 and 14, ring footage that was obtained by the owner of 4014 North 19th Street, that you testified to obtaining the ring footage the same night. Were you aware that, well, let me back up just a little bit. How were you able to obtain that ring footage?
There was officers that went to Freighter Hospital where Dawn Woods, Mr. Brooks's mother, was working. They spoke to her, and she's the one that alerted to them that she had ring video at the house and offered to remotely download that video for them.
And were you there yourself?
I was not there myself.
When did you yourself speak to the owner of that home?
The last time that I spoke to Dawn Woods was on August 8th of this year. I may have spoken to her a few times before that. I don't recall the exact dates.
I'm referring to the first time that you spoke.
I don't recall
the first time.
I don't recall the first date when that was.
And you did just make reference to an August 8th date. And what was the extent of that conversation?
Objection calls for hearsay.
Grounds.
Sustained. Hearsay.
The August 8th date that you referred to, was that in any way follow-up? Was that follow-up investigation?
Follow up to what?
Well, you stated that you had spoken previously before the August 8th date. So the question is, was the August 8th date follow-up to the investigation that you were already actively lead of?
I mean, everything is related to this investigation. The investigation continues every day. It's not end. It will not end until this trial is over.
So what follow-up was needed at the time of the August 8th interview? I'm guessing that's what you would call it. I don't know. I'm not sure.
What, bud?
Objection still calls for hearsay, Your Honor.
Sustained.
Why did you need to talk to Ms. Woods multiple times?
Because every time we spoke to her, we got different information. And at that time, we were following up with your niece and nephew of what their testimony would be in this case.
What testimony are you referring to? Because I don't recall any nieces or nephews testifying.
I don't think I'm allowed to say it.
I think this line of questioning is irrelevant, Your Honor.
I'll sustain the objection, and at an appropriate break, I can address it further if need be. Please move on to a new topic, sir.
You made reference to people who were injured at the parade inadvertently. You recall that?
Yes, I do.
To your knowledge, were any of those charged?
My testimony before is that those people's cases were not charged.
And were they seen as victims?
Going to object to the form of that question. I think it calls for a legal conclusion, Your Honor.
It does not. I asked to his knowledge.
I'll sustain the objection as to the form of the question. If you could please rephrase.
I'm gonna go a different route. Do you recall serving a warrant to the Waukesha County Jail on July 1st of 2022?
Yes, I do.
Do you recall what that was for?
Yes, I do.
And what was that for? Can you state for the record and for the jury?
It's for Mr. Brooks's jail cell.
And why did you serve a warrant for a jail cell?
Your Honor, I object pursuant to legal rulings previously issued in this case. I don't think this is relevant.
I'll sustain the objection. It's not relevant. I'll certainly take it up at a later point if need be.
What was the warrant pursuant to?
I sustain the objection. Next topic, please.
He did answer.
I sustained the state's objection. I'm directing him not to answer. We'll take it up separately. I'll have you continue with your cross-examine. I'll take it up later.
Yeah, what angle do you guys think he's going to take when he gets a chance to open up his defense, his side of the case? Is he going to go for the inability to prove that it was him? Is he going to say that it wasn't him? Is he going to say that he was under the influence of somebody else's control? What that he has a brain scanner and there's something going on where there's cosmic interference from an alien outside influence. Who knows? But
You made
I'm curious what
reference
you guys
to
think.
this vehicle driving into you, but stated you were not injured. Did you file a claim in this matter?
No, I did not.
Do you consider yourself an injured party in this matter?
No, I do not.
Do you yourself know if anyone filed a claim in this matter?
Do you
Can
know
you
the
be more
plaintiff?
specific?
Have you seen the
Do you
plaintiff?
yourself know if anyone filed a claim in this matter?
Yeah, Rose. Yeah, I'm not Mr. Brooks, so if you
Just
wanna-
in general?
Whatever your interpretation of that will be.
I would say yes.
What's the objection? Interpretive.
And do you know what that claim was?
I would imagine that there was a lot of injuries from the people. A lot of people had very extensive medical bills. I imagine that they would file a claim with their insurance company to have those bills paid.
Now I was going to ask if that's civil or criminal. Watch.
So you had knowledge of what was filed to their particular insurance companies?
I have no knowledge, but my assumption is that they would have filed those bills.
So it'd be fair to say you don't know for sure.
That was my testimony.
Is that the answer?
Yes.
The words he said, so you might want to listen. But yeah, he's poking holes as best he can because his whole thing is he's going to go for. You guys, please share the stream because this is going to be next level as per the. I really want to hear thoughts and interact with you guys in the community. This is an interactive viewing of this case, and I think it's important that we get a chance to talk about what's going on because it's going to be could be precedent-setting situation.
As lead investigator for this matter, where are you?
But share it out.
To your knowledge, aware of any
I'd love to see 1,000 people in here. That's the goal by the end of the day.
GoFundMe type of things?
Objection
relation to-
relevant? I'm sorry.
And keep in mind, he had a $5 million
do you mean
bail
as it
that a
relates
GoFundMe
to-
was
As
in
it
place
relates
for
to the
him.
incident.
Got dropped
Or
immediately.
the witness may answer.
$5 million.
I have no direct knowledge, but I assume that there are some GoFundMe pages out there. It's typical in something like this.
And what do you mean by typical? You've seen this before? Is that what you mean by typical?
We have a very loving and caring community where a lot of times when bad things happen to people, people pull together and offer financial assistance to help people.
Is it fair to say that there's a lot of communities like that across Wisconsin?
That's what's your version of a lot,
Yes, I think there are.
But Wisconsin takes care of their own. So yeah, I would say that I would say that, but that's speculative because what's your version of a lot? But yeah, Wisconsin has shown massive amounts of rally and support behind everything that's happened out there in the course of the last 2 years. That's a strong group and a proud people. So yeah, the Wisconsin takes care of their own.
Fair to say that you've worked extremely close with the district attorney's office during the entirety of this matter. Would that be fair to say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
I would like you to define it extremely.
I'll answer yes if that helps.
To your knowledge, do you know if it's typical for a lead investigator to sit right behind the prosecution table at a trial?
Yes, it's very typical. It happens in most larger cases, especially a case of this magnitude. There would be a court officer. So yes, that's a very typical thing that happens.
Have you ever done this before?
I've done this multiple times before.
And are you the only detective in the investigation that has that honor?
Objection vague.
Grounds.
Sustained as to the form of the question.
Are you the only detective directly involved in an investigation that sits with the prosecution?
Talking about this case or any case?
This particular case.
I'm sorry, you interrupted me. Could you repeat that, please?
I believe he said this case.
I'm referring to this case, yes.
Could you re-ask the question, please?
Are you the only detective actively involved in this investigation that sits with the prosecution in reference to this case?
Yes, I'm the only person, the only detective that's sitting with the prosecution during this trial.
So would you explain who the other officer is in the blue suit over here?
Objection to the relevance, Your Honor.
Grounds.
Sustained.
I just want to know his role.
Sustained. Next
Reason
question,
for the
please.
sustain.
Not relevant.
He's been in the courtroom the whole trial. How is it not relevant?
Mr. Brooks, next question, please.
Nobody knows who he is. That should be known. Nobody said
It's
that.
not
back
relevant to
I
the
don't even
issues
have a
that the
back tape.
jury needs to determine. Next question, sir.
Action, we're telling. I'm assuming that's asking. You know what the other one would entail.
Do you have a question, sir?
Yeah, I do. I would like to get to it. Thank you.
Please do so. Thank you.
I will. So seeing as how you sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim?
Objection.
Grounds.
Legal conclusion.
Grounds.
Sustained.
You are aware that only a living, breathing human being can actually file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Objection.
You are
move to
aware of
strike.
that, right?
Go ahead, Attorney Apper.
Move to strike the statements by Mr. Brooks. Also object to the question that was asked at the end as irrelevant, argumentative, and calling for a legal conclusion.
Objection is not calling for a legal conclusion in any way.
The court sustains the objection. The request to strike the statements made by Mr. Brooks are granted, or the request is granted. The jury will disregard the statement and the question asked for all of the reasons indicated by the stated, also as a misstatement of the law.
No, I definitely object to that, Your Honor.
Your objection is noted. I'm going to have the jury stand for a second. They've been sitting for quite some time, and then you can formulate your next question.
I'll take exception to that ruling. And would like a legal finding of fact.
Your objection is noted. It's overruled.
And that's a judicial determination.
Pardon me?
That was before the
Don't
princess
get
went.
brazen with me.
I thank you. Be seated.
Got to hit him with that Schroeder, man. I'm sorry, I've been holding back on him, but man, we're going to have to keep dropping those on him. This guy, man, this guy.
Have you ever had any interactions with this entity, state of Wisconsin?
Mr. Brooks, under 906.11, I'm not going to allow the witness to answer. It's vague.
There was no objection.
Under 906.11, I shall exercise reasonable control over the mode and order of interrogating witnesses. Please, next topic. These questions we addressed during the initial cross-examination of this witness.
They're going to keep coming up.
And I determined at that time that they weren't relevant. So next topic,
They're going to
please.
keep coming up.
Under 906.11, sir, please move on to a new topic.
They're going to keep coming up.
For the cross-examination, I will end.
Do you see the state of Wisconsin present in the courtroom today?
Objection.
Argumentative,
Grounds.
irrelevant.
Sustained.
Grounds
Final
for
warning,
sustained.
sir. Next topic or the cross-examination, I will
You
bring it to an end.
don't got to keep doing that, Your Honor.
Boot him,
Don't gotta keep
boot him.
doing that.
Throw him out, throw him out, throw him
It's my
out.
responsibility, sir, over this trial.
I'm informed. And
Thank you.
And I
Next
respect
topic.
that.
No, you don't. You don't
But it's
respect anything
relevant
about
for the
this
jury to
proceeding.
know the truth. They deserve to know the truth.
Do
Move to
they?
strike, Your Honor.
Granted,
Yep,
the jury will disregard
Regret.
those last statements. They're
Objection
not
to that.
relevant. Mr.
Moving
Brooks is
on.
not testifying. They misstate the law.
I object to that. That's not lawful law. It's
Noted.
untruthful.
All right, under 906.11, I am now
The mommy
stopping
hammer.
the
There we go.
cross-examination. Any redirect by the state?
Objection to that. And I would like a
Noted.
legal finding of fact.
Attorney Opper, any redirect?
Yes, just very briefly, Your Honor, I would like to display for the witness only Exhibit 178.
Objection.
I haven't seen the exhibit yet, so I'll take
Well,
that under
I'm
advisement.
objecting still because the
You may show it to the witness.
there needs to be an answer to why the jury's not being told information that they deserve to know.
Go ahead, Attorney Opper.
Your Honor, for the record, this is a video. I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
And this seems objection because this seems like a whole new exhibit. This was never mentioned before. It was never.
I haven't seen it. I can't rule on it, sir, so let me see it, and I'll
when
take
did
your
it become an
objection
exhibit?
under, I'll take
It
the
was never an
objection
exhibit
under
before.
advisement. Go ahead.
I haven't seen this in any of the exhibits that I have. So how could it just be created now and be made an exhibit?
Go ahead,
I
Attorney
have
Opper.
all the exhibits.
Go ahead, Attorney Opper. I haven't seen it yet. There's nothing on my screen that I can see. I see it's now playing.
So now we just creating exhibits now.
This guy, man. Oh, jeez, this guy. Everybody is just ready to,
All right, you can stop.
you know.
Sir, do you recognize what's contained in State's Exhibit 178?
Objection,
Overruled.
relevancy,
Overruled.
leading.
Go ahead and answer.
Yes, I do.
What is it?
Objection, leading.
Overruled. The witness may answer.
I'm still going to object. How is this?
Mr. Brooks, I ask that you
I
honor
have all
the ruling that
I
I've
have
been
all the
made.
exhibits, though, Your Honor. I have them
Mr.
all.
Brooks.
They were provided to me, and this was never in the exhibit. So how could it just be made an exhibit?
I'll take
just
this
out
up
of the blue?
outside the presence of the jury, but I'm going to allow it.
Can that be stated for the record? Can that be explained?
No, the jury will disregard the statements made by Mr. Brooks. They're not evidence, and the statement
So this
continue.
exhibit shouldn't be evidence then, because it
Mr.
didn't
Brooks, the
exist before
objection's
today.
noted. It's overruled. Go ahead.
There was a still photo shown before of Mr. Brooks standing in front of the Ford Escape. This is the video in which that still photo was taken from.
Objection. How does he know that?
Overruled. The witness may answer. I'll give you the opportunity to question him about it when the state's done asking the questions. Go ahead.
Where'd you get this video from, sir?
Objection leading.
Overruled. The witness may answer.
From Mr. Brooks' social media account.
Your Honor, move to admit 178 and permission to publish.
Objection to the relevancy.
I'll find
Still
that's
don't know how
relevant.
it's
I'll
obtained.
receive Exhibit 168.
It
Permission
doesn't
to
work for me in the
publish
defense
is
of my case. Could you
granted.
go ahead and take the objection,
For the
please?
record.
It's 178, Your Honor.
No, could you please tell me the length of the video?
Yeah.
The length is 2 minutes, 33 seconds. We're going to play it in its entirety, but without volume, Your Honor.
All right, thank you.
And
I object to that. And I would like to make an offer of proof of my appeal.
We'll do that outside the presence of the jury, but I will allow the state to play it in its entirety without
Your
audio.
Honor, I have all the exhibits. They were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to
But
address.
how can you play something that I didn't even
Mr. Brooks,
have?
I'll take that up outside the presence of the jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
Mind-boggling.
actually, Your Honor, I changed my mind. I would like to play the audio, please.
This is mind-boggling.
Is he saying bottling or
I
boggling?
want to have it played first without,
Yeah, like
and
the
then I'll make a
lines on the
ruling and
bottom.
I'll take that up.
Okay, I understand.
Thank you.
So we will play the entire video, Your Honor, 2 minutes, 33 seconds.
I object to that. Why does the whole video need to be played? Is this setting the foundation?
It's relevant. You questioned the officer about it. You
I
questioned the
question him
detective
about
about his knowledge.
the steel frame from the video. The video wasn't even in the exhibits that I received. I actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop. The jury will disregard his statements. He's not testifying. The video's playing.
So play the sound. I want to hear it now.
I'll address that later.
We address why it was created out of the Bluetooth.
He wants to hear the sound, right? He wants to hear the sound. He wants to hear how cool he sounds in his rap video. But you're not getting any free play here, pal. Got the production quality, the shaky cam work, the water gun, his mom's red SUV. Impressive use of a wife beater, I gotta say. That's a tough one to pull. And this man, he's got swag. You can obviously tell. Nothing says thuggin' like 3-foot-long dreadlocks and a widow's peak. Looks like his hairline's practicing social
Go ahead, attorney, after
separation.
the video's finished playing.
Thank you. Sir,
Taking
did you
COVID
see
precautions.
during the playing of that video, the image that was captured as a screenshot and presented to you in your direct testimony as states exhibit number 175?
Objection leading.
Overruled. Foundational. The witness may answer.
Yes, I
A lot of.
You were questioned on cross-examination as to your ability to identify Mr. Brooks in exhibit 175, correct?
Objection. That question was asked initially by Attorney Hopper.
Overruled. The
Yeah.
witness may answer. Sorry.
Yes, I was.
As you just watched the entire video again now in court, as states exhibit 178, did you clearly see Mr. Brooks in that video, sir?
Objection leading.
Overruled. The witness may answer.
I believe there's no doubt that that's Mr. Brooks in the video and later standing next to the Ford Escape.
Thank you. I don't have any other questions, Your Honor.
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Casey.
Objection. I don't consent to being called that name. And yeah,
Noted. Do you
that
have any
question.
questions for the witness?
This when did this video? When was this made a exhibit? Because I don't have it.
Objection. That's not a question for the witness, Your Honor.
That
Sustained.
was a question. The question. When
Sustained.
was this
As to the
video
form
made
of
an
the
exhibit?
question,
When was this video made an exhibit? That is a question.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
sustained.
Well, he said he saw it.
That's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
With the understanding that you're asking, when did he see the video? I will
When
allow
did
the
you see
question
this
to be
exhibit?
asked. With that understanding, you may answer, Detective Casey.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table?
I-
It would be the same thing. I'll take that as disrespect because they were allowed to say something and I said under my breath that was disrespect.
I
They
would
just
direct
did the
both
same
parties
thing.
to avoid commentary.
Okay, well, can
and
you do that,
gestures
please, and
faces.
admonish them?
Yes,
Because
I
I'm
will.
always the one getting
Absolutely.
admonished.
Everyone.
I take that as disrespect too.
Sir, I'm good. Can I do my job? State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody
However,
ever see nothing.
How is he even want to talk
I'm
about
advising
people
both
laughing when he's
parties
sitting there?
to show
Come on, man,
decorum
this is not fair.
and restraint,
That's all he's doing is laughing, rolling his
to
eyes.
be respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey, you can answer the question about when you have seen this video prior to today.
Yeah, he wants to be his rap.
I
name.
saw the video
Boy Fly.
within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
Why did you need to review it this morning?
Objection, argumentative.
Overruled, the witness may answer.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a
Grounds.
misstatement, Your Honor.
Sustained
It was
as to the
not
form
brought
of
up
the
in
question
earlier
assumes
testimony.
facts not in evidence.
If you have seen it numerous times before today, why did you need to see it again to make sure if any questions were asked or however you refer to it? What would be the need to view again this morning something that you had viewed numerous times before?
I'll stay with my
Objection, objection, compound, asked and answered, misstatement of the facts, argumentative.
Sustained.
Did you view the video this morning because you knew that the video would be made an exhibit this morning?
Objection assumes facts, not in evidence.
Sustained. As to the form of the question.
This is mind-boggling. This is mind-boggling. Can you clarify again why you viewed the video this morning?
Objection asked and answered.
Sustained.
So you're gonna sustain everything?
It was already answered, sir. Next question, please.
And I'm asking for clarification.
Next question, please.
I don't got no more questions, man.
All right, thank you.
This is mind-boggling.
Detective, you may step down. I'll excuse the jury.
What you people is trying to do is not fair. Hide things from the jury repeatedly. Don't tell them all the information
Mr.
they
Brooks,
need
I'm
to
going
know.
to take up all of your objections outside the presence of the jury. I ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's the only reason, because you asked. I see what you people are trying to do. It's not right. It's not fair and it's not right.
You can have a seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence. All right. First of all, Attorney Opera, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr. Brooks, I need to make a record. So just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
Are you telling me to sit down or asking me to sit down?
All right, based upon the offer of proof provided by the state, and it was provided to prior counsel, that satisfies me as to that issue. I indicated I would.
Accurate, Your Honor. Can we have the prior counsel testify to that then?
Not at this time, sir.
I have not obtained that. Right now, that was my first time seeing that as an exhibit.
Mr. Brooks, I presume, and you can correct me if I'm wrong, but you're familiar with that video. Yes or no?
What does that have to do with what we're talking
Because
about?
I'm going to make a finding based upon what I viewed in that video,
Yes or
that
no?
there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons. The first of which, it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that and what relevance, if any, that evidence have. But you opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it. Because the still image was of your back.
Okay.
So that opened up the door and it's proper. There's absolutely no surprise to you that that video exists. And that is my finding as it relates to that. What do you mean by it's
no surprise to me that it exists? That was not the issue. The issue was how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue.
State can make an offer of proof on that because obviously they marked it as an exhibit.
Well, with all respect, Your Honor, you're mischaracterizing what I said, and the record needs to be clear. The issue that I raised was how does this at the last minute, out of the blue, become an exhibit. That was the
Go
issue.
ahead and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well
Objection.
aware.
He said social
There's
media. He
nothing
didn't
that
say what it was.
Sir, stop interrupting. We have to make a record of it. You've
Then make the record clear.
interrupted multiple times. I've been abundantly patient
record
with
clear.
you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at
asking me
me.
to be quiet?
Stop rolling your eyes at me.
Are you?
Stop
I'm
mumbling.
looking right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and
looking.
I've made note
I'm
of
looking
it.
at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Go ahead, Attorney
That was
Alper.
before the
Thank you,
closed
Your
session.
Honor.
Okay,
And
that's
just
me.
to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video, which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks, because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did, because he pushed it again, and his voice and his mannerism of speech, I thought, would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant, who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up. And whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks, because again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up two other issues. There was an objection to questions regarding cross-examination. So the objections were by the state. One had to do with there's questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction? I believe it was with your mom and possible testimony of your niece and nephew.
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
I don't know specifically what you're talking about.
There's a reference made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling on an exhibit.
She's been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's towards me. I'm not an idiot.
I haven't made any of those observations.
I didn't say you. I didn't say you, Your Honor.
No. What I've observed is
listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot. That is very disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't know what you're
laughing under her breath. Her trying to cover up the microphone so they can laugh and he and key. That they've been doing that the whole time. I didn't say anything. I didn't say anything about it.
I have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I haven't noticed that other than the one thing you pointed out.
Well, we have cameras. That's what the cameras are.
Because you are a
Let's
clown, and we
refocus
find it
our
entertaining.
attention on what we're here for, and that's
okay,
this trial.
I take that as.
And do you have anything you want to put on the record?
I'm putting it on the record.
No, you need to let me finish. As it relates to the video and my decision to admit it.
She just admitted that she just now came with the exhibit. It was not that she just said, she just made it an exhibit. It was not an exhibit before she made it one.
So do you have some legal basis, sir, for your position? Because I'm not.
What do I need legal basis for when she just admitted on the record that she just made this exhibit up right now?
That is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't implying that by saying that she could pull anything out of her suitcase.
So that's a figure of speech.
Okay, so what is it implying to? What would that be implying to?
As
how would anyone in my position?
Because you're not providing me with any legal basis.
I didn't even finish. You told me that I can make the record. I'm attempting to make the record.
Sir, as it relates to the video and my
this is getting out of control. If this was an attorney, you would be 100%.
You're not letting me finish.
You didn't let me finish either, Your Honor.
Because you're not providing me.
But how do you know I wouldn't get to that
commentary? You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at audience?
I've already made a ruling
Because no
on
one wants to
that.
hear your
You're
crappy rap
questioning
video, dude.
the ruling.
We're
You're
watching
not
it. We need to hear
asking
it.
me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Too much.
Yes.
Yeah,
that's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that?
The bottom line is you opened the door to the playing of that video.
We're not talking about
and the
opening
video
no
was
doors.
previously provided to you during discovery.
We're not talking about opening no doors. We're talking about being fair.
There's absolutely
Because if
no
I would have did
prejudice
that,
to
Your
you
Honor,
in
with all
terms
due
of
respect,
surprise.
with all due respect, if I had done that,
I am going to move on.
if
from
I
this
had done
topic.
that, it would have been a big
I'm
thing.
advising you.
Are you asking me?
I'm advising you, sir.
Do you understand?
I'm advising you to sit down and be quiet.
And
if you interrupt me again, you are on notice that you will forfeit your right to be present in this
So you're
trial.
holding me contempt
Mr.
for the
Brooks,
entire trial? Did you say the entire trial?
I never said any such
You said
thing.
for the trial. So what do
Please?
you mean? I'm asking, what do you mean?
Mr. Brooks, you continue to
That is
come at
not,
me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you. I'm not.
I'm
But
going to give you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and be quiet so I can make a finding
Are you
as it
asking
relates
me
to
to
other
do
things.
that? Are you asking me
I don't need
do
to
that?
ask, I'm telling you. Thank you. There were
He's about to
two
answer
other
now.
issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August. And there was some reference to his niece and nephew.
He's doing exactly
And
what
I
he's saying.
sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics? Is my first question.
Okay, why was it an issue with me bringing this?
Mr. Brooks, I'm only going to ask you one more time, and if you don't
I'm saying,
answer
if I don't
correctly,
understand,
then
if I don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please.
Because you don't.
I'm going to ask this question one more time.
Man,
It calls for
I
a
don't like
yes or
I don't
no.
like your tone and the way you're talking to me. I don't.
Mr.
I don't
Brooks?
appreciate it.
Before the
Sit down.
get brazen with
I don't
me.
care if you don't like my
I'm not
tone.
gonna-
You've
I'm
been
not gonna
pushing
sit
my
down.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too.
the utmost of respect
No,
for
you
you,
haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to call it, that's fine, but it's
Stop
not accurate.
talking.
What you mean, stop talking?
I need to
Stop
make a
talking.
ruling. Okay,
Well,
I'm
let's-
purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's
right
talk to each
now.
other like adults then.
Mr.
Because
Brooks,
I've never told you to stop talking.
You have. You said be quiet and
I'm
listen.
going to
to me.
ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the
All
question
right,
about
he's
the
not
jail
answered
cell?
my question. We'll move on.
I'm
not
trying
giving
to
that
understand. If I
opportunity.
don't
We're gonna take a
understand,
break.
how do
We're
I
in
know?
recess, 15 minutes
How do
from
I
now.
know
Take
what
care,
I'm
everyone.
supposed to answer if I don't understand? And I don't agree to a stop.
Finally said, "Hey, I've had enough of your nonsense, man. We're gonna take a recess. Hopefully, they don't go away. I'm hoping that they cut back, because usually when they do these recesses, these quick breaks, they jump back in, and you get to hear a little bit of the tete-on-tete between the judge and old Darrell Brooks here, man. This is like next level, though. I don't know how you guys are feeling while you're watching this, but as I'm seeing it, he's taking this to the next level. Like everything he's doing at this point is done to. I mean, if he were actually an attorney, as he represents himself, he would definitely have been kicked out, and more than likely, like, he'd be held in contempt. They'd be looking at just disbarring him, as somebody said, like, throw him out completely, because they could put him in that other courtroom. The judge is doing her best right now to try to not hold him in contempt, because that's what he wants, because somehow he knows that's going to play into his favor in some way. I don't know how, but he's at a point now where he's just being given free reign. Like, I'll put together a post over or a poll and just see what you guys think about it. But do you feel like the judge has allowed it to be this way because she's been so lenient? Because for me personally, he's been told so many times, this is your final warning, your final warning, final warning. And then he gets to keep running off on the mouth. Like, it's wild. Here, let me show you this clip while we're in 15-minute break. Let me play this one for you. This was yesterday. And it started 1 minute. You guys, this is 1 minute into the trial. 1 minute. This will blow your mind. Yeah.
I've taken the jury out at this point to admonish you that any further mumbling under your breath or not recognizing when I uphold or sustain an objection, that I will take as a disrupting interruption meant to disrupt the proceedings. I'm not holding you in contempt. I'm well aware that that's one of my options. I choose not to do it for the reasons that I've stated on the record previously. All right, you can forfeit your right to be present at any point in time during this trial by your conduct under Illinois versus Allen. When it is disruptive, when it does not follow the simple rules of courtesy and decorum, I draw your attention once again to SCR Chapter 62, which has been previously provided to you, which is under the statute there. These constant mumbling and interruptions during the proceedings. I haven't made a record of them today, but I will now. Started at 9:01, then there was 5 at 9:02, 3 at 9:03, 4 at 9:04, 1 at 9:05, 2 at 9:05, 1 at 9:06, 3 at 9:08, again at 9:17, 9:27, 10:31, 1:05, there was talking over by you at 2:03, 5 interruptions at 2:14, 2:15, 2:17, at 2:19, audible muttering, 2:31, 2:33, what I would describe as inappropriate, like muttering under your breath, 2:35, at 3:06, there was a hilarious comment, at 3:11, there was what I would describe as arguing about the muttering and the irony of it all. At 3:12, there were 4 interruptions. At 3:37, more 4:09, 4:10, more mumbling. At 4:11, twice, and at 4:12, 9 different times. So I think I've made an ample record of the disruptions today. I've been abundantly patient with you.
Yeah, abundantly patient. 54 outbursts in 5 hours. That was starting at 9:01, and that was only up till 4 p.m. And then they went, a little longer. And I think it went long yesterday. I don't know how long it went, but 54. She just had them straight start like documenting. I was trying to keep a checklist over here while it was going on. I was just hash marking every time he would object. I didn't even know what they were considering to be an outburst or what they were feeling was, a disruption. But I realize now, as we're watching this, everything he's doing is a disruption. He's doing all this just to disrupt. But the detective was great. He basically broke it down and was like, listen, man, like they're getting better. The witnesses are picking up on what's going on right now. They understand now that the questioning that he has is a roundabout way of just distracting us from what's really happening. What he's trying to do is water down and convolute the witnesses' testimonies and statements that they're giving on the stand. And so he's doing his redirect, and it's done for nothing more than to just confuse and to distract. Mind you, and if you're just jumping in, please share the stream, because it's going to be, the day has just started. Like we just started the day. And I know that sounds like a long day for folks, because we're already almost 3 hours into it. But I mean, the day just started, because Darrell Brooks at this point hasn't even started his trial yet, his trial. So he hasn't done an opening statement. He hasn't presented his case. He hasn't presented his defense. He hasn't done anything yet. All he's doing now is receiving from the prosecution their case. They're giving him their witnesses, their evidence, and their goal for what they hope to accomplish in this and throughout the litigation of this case. So Darrell Brooks here still hasn't had a chance to wow us with his amazing amount of courtroom knowledge and his, the spectacular in-depth ability to play, his own Johnny Cochran. This is to me, I'm amazed. I'm amazed that the judge at this point has been so incredibly lenient while their witnesses on the stand, because the witnesses at this point, with all of the witnesses, so I won't say all of them, but with many of the witnesses were also victims, directly affected. Even, the last detective that was on the stand just now, Detective Casey, he even was struck by the vehicle. He said he wasn't injured, but he had to bang on the hood of the car and tell him to stop, and he kept driving. So even in that, that's traumatic. I remember as a kid, I was on my bicycle crossing the street once, and a car went to make a turn, slowed down, didn't see me, was looking the other way, and clipped me, right? Knocked me off my bike. Not a big deal. I got a skin knee, not a problem, right? This is just falling off my bike. I was terrified to cross the street with my bike after that because of the moment where a car just pushed me over. And I probably didn't even have, the gas on, just rolled into me, doop, knocked me down. I remember for years, I wouldn't cross the street until a friend pointed out, "What are you doing?" I'm like, I'm not trying to get off, and I do the walk. I was afraid to be on my bike because of that one time. I can't imagine what it'd be like for anybody who's witnessed this happen. Anybody that was there watching it live, all the people that were directly hit, the dozens and dozens and dozens of people, that'll go with you forever. That's going to go with you forever. Hearing a car rev, these are things that people look past in the PTSD aspect of it. I can tell you just from and granted, I'm not in any way, shape, or form leveraging my experiences with what these people, the reality of what they've experienced throughout this Waukesha Parade attack. But in some of my experiences throughout the riots and things that I've been involved in for the last couple of years, even the sound of like a metal can hitting the ground, that tink, 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 immediately I clench up because it's the precursor to either tear gas or a flashbang. Like the flashbangs that they would shoot into the crowd or lob into the crowd, they would skip ... and they would make that metal tin can sound, and then an explosion would happen, and typically it'd be followed with somebody running and kicking you in the chest or smacking you in the face with a nightstick. But all of which happened. So to this day, I get nervous whenever I hear the sound of metal. I kind of jump like, oh no, it's going to explode on me. That's just from being around protests and things like that. That wasn't an attack per se, like as in we're seeing with this amazing spectacle that's being brought around from what was just a blatant crime, And so what he's doing, to be clear, in my opinion, this is my opinion, we'll find out more today when he opens his side of the case, is just trying to push for an appeal that might work. He's poking holes in everything he can. He's really working his ass off to hope that he can prove that the state of Wisconsin is an entity, and an entity is not a person. And if there's not a person present as the injured party or the injured party, then there's really no case, and there's nothing that they can prosecute. So, and then he's saying on the back end to double down, he's trying to really give himself, the reassurance that if that doesn't stick, well, I'm not actually Darrell Brooks. I'm here, third party, as he said, representing the defendant, the alleged defendant, Darrell Brooks, because he's pro se, and we've talked about that. And if you guys don't remember what pro se is self-representing, right? So he's got this sovereign citizen thing that he's going off of too, that he feels that he's sovereign, which in maritime court, he'll go through different things. And I've had some links I'll put up here for you guys to check out, and maybe a quick YouTube video. You can pop over to YouTube and check that out as well. I'll try to put those links up in Facebook or in the description here at some point. Actually, I just said that. I don't even know how to really do all that. I know how to do most of it, but some of it's kind of foreign. The links in the description. Check out the bio, whatever. But these videos about what a sovereign citizen is. But as it says here, they believe that they're at this political movement, that they oppose taxation, question the legitimacy of government, and believe that they are not subject to the laws of the courts. On a federal, on a state level, I think that they still, and some groups are different, they still feel that they adhere to the federal policy, but not the state level. So, and sorry, the sound of the whooshing sound is my computer here cooling off, because even my computer's getting heated about this whole thing. But but make no mistake, the charges right now, 6 counts of first-degree intentional homicide. And one of the things he brought up was with this detective was that he honked his horn, and he's trying to, what he was going for was saying, well, why do people honk their horns? And the high beams, they talked about that when they viewed the vehicle yesterday, when they talked about that the high beams were on. You know, why would someone have their high beams on? And they're talking about so they could be more visible, so you can see the car coming. Point in that, you're driving up and smashing through people from behind him. Your high beams aren't really doing much. Also, he's saying he honked his horn. So if you look at the first counts, right, 6 counts of first-degree intentional homicide, the burden of responsibility on the state is to prove that he intentionally meant to kill these people. Okay, the fallback from that. Now, each one of those carries a life sentence. If he's found for first-degree intentional homicide, first-degree murder, life sentence. There's no death penalty in Wisconsin, but if he gets a reckless homicide, I believe that the penalty for that is up to 30 years. So even at 30 years for 6 people, so he's looking at 180 years on that, even if it's a drop back. So, you know, let's lean on that one. Now, if you move past that one to 61 counts of recklessly endangering safety, those have a 12.5-year cap. So if he gets 61 counts at 12.5 years, it's 70 plus years. We'd have to ask the Siri here. Hey, Siri. Hey, Siri. What is 61 times 12.5?
61 times 12.5 is 762.5.
Yeah, that was my quick math. 762.5 years if he gets found for just recklessly endangering the safety of these 61 people. 6 counts of hit and run involving death. I believe that those are punishable by up to 25 years in prison. So you're looking at another 150 years there, right? Am I right? 25, 50, 75, 150. Yeah, we're good there. Those charges alone, between the 762 plus, 150, you're looking at 900 plus years and 6 life sentences. Now, if he gets hit with reckless endangerment or reckless homicide, that's 30 years. So he's looking at 180 plus 150 plus 760. The guy's not going to make it a year in prison, though. Keep in mind, he is an unregistered, convicted child rapist. He raped a girl when he was 26, who was 15, who he was running as a prostitute out in Las Vegas that he took from Oakland because, as he said in the video I showed you guys yesterday, yeah, she wanted to hoe up. I wanted to run a pimp game. Matter of fact, let me show you that real quick. I'll show you guys that video of when Darrell Brooks was, running his pimp game, if you will, on this 15-year-old girl. Now, the 15-year-old girl that I'm talking about here, he got pregnant. And which, I mean, he talks about his children, right? He keeps bringing that up. And of those children, one of those is a child that was born out of the statutory rape of a 15-year-old little girl. So, I've got the video here for you. And if you guys remember yesterday, I don't want to, you can't say comical, right? You can't say that in this situation, but what you can do is appreciate the levity that comes in with the way he approaches all of this, and the fact that he feels like he has some grounds, some level of of reasoning behind him, saying like, I don't feel like this is proper. I don't feel like I'm getting proper treatment. I don't. Yeah. He was running her as I'll show you the video. Sorry. It's up here in my, I just have to pull it up and we'll take a look at it. Here we go. All right, cool. And yeah, here we go. I got you guys. Sit tight. It'll be up in 2 seconds. Yeah, this is the one right here. So this is by Ike DeMel on, I believe it was TikTok at some point. I'm not sure. Or it was a reel. Sorry, it was on Instagram Reels or Facebook. I don't know where the reels come from, honestly. So, but it was a reel. So this is him. And I'm going to let you, he can tell you what exactly he meant, what he was doing with this 15-year-old girl. And then we'll go back into court. But we got to get over here. Boom.
Then as soon as we fall out, all of a sudden now I'm a pedophile. Let me explain that. 10 years ago, 2006, I caught a case with my oldest daughter's mama. Yes, my baby mama. She's from Oakland. I was busting moves in Nevada. I meet the bitch. She says she want to get down, so I'm pimping on the bitch. I take her to Nevada. You know what I'm saying? I get cracked. You know what I'm saying? I didn't know the bitch was 16 at the time. She gave a statement to the police and told them, yeah, she was hoeing, that I was pimping, and that she was 16, and that I didn't know that. Okay. And then as soon as we fall out, all of a sudden now I'm a pedophile. Let me explain.
So there he is explaining how all of a sudden he's a pedophile because she filed charges against him because they had a falling out. This is where I think his convoluted view of the law is kind of at this point. You don't become a pedophile when you get caught raping a child. You become a pedophile when you rape the child. When you do that, you're the criminal that's doing that. You don't become the criminal once you get caught. That's that mindset. Well, I'm innocent until they prove me guilty. Yeah, okay, in a court of law. But let's look past that. All right, we all get that. Take a step behind the curtain on that one, right? Like, if you're committing the crime, that's a term for that. And like I said yesterday, you're not guilty of stealing a car when you get caught in the car you stole. You're guilty of stealing a car the second you steal said car. So the things that he's done, he's on the back end trying to prove that in some way, shape, or form, like he's good, right? Like, well, you got to prove that I did this. You got to prove that. No. We know what you did. You know what you did. At this point, it's just a matter of how we're going to get it to, or how the courts are going to get it to, to stick in a way where he'll spend, as much time in prison as a human can. Now, beyond that, he's not looking at doing well. Mind you, prisons have a way of taking care of their own. So this guy is going into the prison system as a convicted child rapist. He's not going to make it. General population will eat him up. They will devour him, and especially this guy, he'll be in a Wisconsin state prison. I mean, can you imagine this guy in as they could say, walk in the yard in general population, thinking he's, Billy Swagger with this big, national court case. It's made all this news, and feeling like he's, beat the world with his nonsense and all the streaming BS that he's thrown out there. He's going to walk across somebody who is from Waukesha, who has a grandparent that died, that he killed. But he's going to see someone from Waukesha who was a nephew that was killed. Maybe that 8-year-old was a family member, or someone who just gets word that he raped a 15-year-old and got her pregnant. And that'll be that. They'll handle that. So, best place people say sometimes is like for these types of people is in prison. The worst place for him is anywhere, because he's not going to make it. You know what I mean? He's not going to get back out, and he's hoping for an appeal while he's on the inside, but the inside's going to probably do enough to get him put out. So when they get put out, a lot of times that's in a bag. But yeah, and an unpopular opinionated pariah, you're absolutely correct. So prisons are very segregated, in different races, different cars, as they say, handle things differently about how they allow people into their groups. Doesn't mean there's not crossover. You know what I mean? There's always crossover. This group and that group happen to pass like ships in the night. And sometimes, people spring a leak in the process. So, he is exactly who he is, and we know that. So we're going to jump back into the trial, though. And again, you guys share the stream. I'm going to keep giving you as much information as possible and as many videos. And like I said, it's interactive here. We'll be able to talk about things and get information. You can ask questions, and I definitely have more clips that I'm going to show you as the day goes on, and the day will get interesting. So please share the stream. We got a share goal. I want to get to 500 shares today. That's the goal. So if you got a group you want to share it to, or it was loud in my head. Nobody cares. And
Are there any issues related to exhibits or other things before I bring the jury back out for what I believe will be the state resting?
No, Your Honor, I do believe that I did check with your clerk. Everything that we have offered and admitted matches what the court has. So I believe we are good on that.
I have one question
sure.
about Exhibit 89, and I don't know if I missed in my notes.
Okay.
What do the parties' notes reflect on whether that was received?
I showed that it was offered and admitted before it's published, or it wasn't published to the jury. But if not, we would move Exhibit 89 into evidence.
And do you recall what Exhibit 89 is?
It's a certified bail form.
No, I'm asking.
Oh.
I'm asking Mr. Brooks. So,
sorry.
That was the second of the 2 bail bonds. Do you have a recollection of whether it was received?
I don't.
Right. Then what
I
was
know I objected to it.
Yeah, he's going to have
you
issues.
objected
This
when it
attitude,
was
this bravado,
displayed for the witness who then testified about it.
145 pounds of him is.
I'll receive it
he's
and
gonna sing
also
a whole
advise
different
the jury. Were there any other
Put him in a
exhibits?
jumpsuit and put him on a bus off to
I have one other issue on
whatever state prison they got.
evidence and exhibits as well, but are there going to be any other exhibits that we need to tidy up the record in front of the jury with?
I don't believe so.
You're a rock star, Mo. Thank you so much.
I know at one point, someone caught that we moved, it was either Exhibit 175 or 178 into evidence, and the court admitted either 165 or 168 on the record. So I don't know.
He's basically in PC right now. They've got him on 23-hour
Somebody just had a
lockdown.
misspeak.
Yeah.
Let him,
You have any recollection of that, sir?
with Jim Pop. So
Recollection of what?
Related to what the state just put on the record. Do you know what was that? What witness that was?
yeah,
That was Detective.
Letitia, you got that right.
Look at that.
Thank you, Julie. I appreciate it. That's what we're here for, to have this interactive experience. It's hard to keep a level head, I'm sure, for all of you when you're watching this and listening to what, listening to how this, this guy, this person right
175 was the
going about.
screenshot taken from the video. I know I have
Really
a note
hard
that
to
it was
keep
received and published. And you believe I may have just referenced it by the wrong name?
I thought it was 178. I thought you referenced it by the wrong number.
And thank you again, Karen, for
So it's either 175.
fact finding. Yeah, you're killing it. Thank you.
175 was referenced as 165, or 178 was referenced as 168.
What is 170?
This is why I love our community, man. You guys are all so good at being a part of the information that we're all seeing and what we're doing, and giving us a better understanding of what we're experiencing right now. And
I
what
know
we're a
that
part of.
175 is what I just
Thank you,
said.
everybody
Correct.
in here, no matter what channel you happen to be on.
178.
178 was the video.
Oh, that was the most recent one. Okay.
Yeah, Mama
What's
Red,
the
we don't
request
know.
then as it relates to when the jury comes back in?
Your Honor, I just,
Oh, thanks.
there's
man.
two different
Appreciate
ways
it,
to do this. I can put on the record, I have the exhibit numbers, and I can just put on the record just to verify that these exhibits have all been offered and admitted into evidence, and the court's agreeing, because we've just agreed that those are, your records are the same as my records, or we can clarify just if there was some confusion about exhibits 175 and 178 that were shown to the jury this morning. Those 175 and 178 were offered, and the court has admitted those into evidence. So however you want to.
We're all thinking about you and praying for
Sir, do you have
and
any
your family, Judy.
position on how I address this in front of the jury?
Yeah, I'm objected to him being admitted at all.
Well, those objections were already addressed. I'm talking about how I addressed to make sure the jury knows they were received by the court.
However you gonna do it is how you gonna do it. I don't think what I gotta say much matters.
You need to tell her
What
that.
you say
That's what
matters,
she's
sir,
doing.
but
No,
the
I don't.
fact that I've already ruled on the admissibility is not something I'm going to revisit.
What I gotta say.
Hold on,
definitely
that door's, all right, it's, sometimes that door upstairs malfunctions and, all right, I didn't hear the last part of what you said.
what I have to say about anything definitely doesn't matter.
I take huge objection with that, sir.
It's true.
And that may be your perception, but that is absolutely not true. This court takes your positions on evidence, legal arguments, admissibility, things of that nature. I take all of that quite seriously.
But somehow it's always overruled or discarded.
Sir, can I keep going because you've interrupted me once again? My perspective on all of this, sir, is when you disagree with a ruling, you interrupt, you try to debate the topic again and again, you make disparaging remarks either directly or under your breath that are audible. Sometimes you roll your eyes. I mean, just previous to the break, you and I were talking over each other. I couldn't really get a word in edgewise. You wanted to debate topics that I've already made decisions on. I wanted to get clarification on whether you wanted to pursue any questioning, for example, with Detective Casey. I gave you multiple opportunities to answer questions directly. You chose not to do that. You directly challenged me about my authority in this courtroom. You refused to sit down repeatedly. Did I raise my voice? I absolutely did. Was I frustrated? I absolutely was. I'm sitting down. My voice is calm. I think the break was good. I hope for all it was good for me. We had a very long morning. It was about 11:30 when we broke. It's now 11:54. I didn't remove you to the other courtroom despite my repeated warnings because frankly I knew I was going to take a break. I just wanted to get through some issues outside the presence of the jury, which is the proper procedure for how to address objections if the record can't be done in a way that when a more full record needs to be made is how I'll put it. And I indicated during the cross-examination of Detective Casey, I would take your objections under advisement. I would address them outside the presence of the jury. You chose not to answer my questions, and so I moved on. Now, with respect to, I want to also address exhibits and the normal course of exhibits coming in a trial. Because I think there's some misunderstanding and certainly confusion on your part, sir, about the exhibit list that I asked the state to file near the beginning. And that was frankly to assist the court and my clerk in keeping track. Most trials, the normal course of action is as long as an exhibit has been provided to a party previously, or in some circumstances, it's rebuttal, we're not quite there yet, that as long as it's been turned over in discovery, oftentimes parties will simply have exhibits marked as they're presented in the course of a trial. There's not a legal requirement unless a judge orders it that would prohibit a party from marking a document that's been already exchanged and having it offered as an exhibit. There was nothing improper about what the state did with Exhibit 178. And I want to make that record very, very clear. As Attorney Opper stated, trials are fluid. Things happen. Parties can open the door to what might be inadmissible evidence for a variety of reasons. For example, this court made a number of pretrial rulings related to other acts evidence. Even during your cross-examination today, you came awfully close. I had the witness turn to me and pause and say, I don't think I can answer that, in a clear recognition that that witness, Detective Casey, understood his obligation to honor the pretrial rulings. And we moved on from there. I bet that's happened a half a dozen times in this trial. And that's frankly to protect your rights, sir. the door could have been opened a long time ago to the other act's evidence with Erica Patterson. And I frankly kept it out, despite your questions. So with that, I want to bring the jury back out. I will ask the state. I'll simply just ask the state, are there any anything additional the state's offering by way of testimony or exhibits? You can then address the exhibit issue. Then I'll ask the state if the state has any additional witnesses, and the state can officially rest. Given the time of day that it is, it's 11:58. I'm not going to have Mr. Brooks start with his opening statement. We'll do that when we come back after the lunch hour. I think, frankly, the time over the lunch hour will be good for everyone to regroup, hopefully get a little bit to eat, and come back fresh. And then we'll have his opening statement and the start of testimony. Before I bring the jury out, there's one other thing I want to do, though. I just need a moment to pull something up from on my computer.
So is that addressing subject matter jurisdiction that you're pulling up?
No.
When would that be proven for the record?
Sir, please don't interrupt me. I need to focus on what I'm
not
doing.
interrupting you. I'm just asking a question.
All right. I'm not going to be addressing that.
So would it
don't
be
interrupt me right now. I'm trying to do something on my computer.
Would it be
I need to
proven on the
focus.
record?
He just doesn't stop, man. He does
I feel
not.
it's important at this time to at least give you the advisement pursuant to special material 28. It is regarding.
Thank you for the
your
stars, you
decision on
guys.
whether
I
to
really appreciate the
testify.
help to keep
I'm not
this
asking you to
pumping.
make that decision, but since we're on the verge of you starting your case and it may impact your opening statement, I wanted to go through the following. Sir, are you aware that you have a constitutional right to testify?
I've been informed.
Are you advised and informed that you also have a constitutional right not to testify?
I'm not advised, I'm informed.
Are you advised and informed that the decision whether to testify is for you to make?
I don't understand the question.
Are you advised and informed that the decision on whether you testify in this trial
He's
is
just
for
looking
you
at
and
his
you alone
Bible.
to make?
I'm informed. Not advised.
Are you advised and informed, sir, that if you choose not to testify, the jury will be advised that they cannot use that against you? In other words, you have that right not to testify.
I'm informed.
When you make a determination about whether to testify in this trial, I will further be asking you about whether anyone has made any threats or promises to you to influence your decision. I may also briefly go over your educational background. Did you hear me say that?
No, I'll say it again.
At the appropriate time, when we go through this discussion more fully, I will also ask you whether anyone has made any promises to you to influence your decision on whether to testify. Did you hear me say that?
I'm informed.
And then I will also ask you if anyone's made any threats or coerced you in any way in your decision to testify or not.
What's the significance of that?
So that I can make appropriate findings about the voluntariness, intelligence, and your, whether it's knowing, voluntary, and intelligent, your decision to testify.
So whether I give consent.
that's not the legal determination that I make. It is simply something that is your choice. I will honor your right not to testify. Obviously, that's a constitutional right. I will honor your right to testify. That's also a constitutional right. And the jury will be advised one way or the other. There's a jury instruction on that. Did you hear me advise you of all of this?
I'm informed.
All right. Okay, let's bring the jury out then. We can kind of tidy up the record and then we'll break for lunch.
Judge, may I remove that exhibit, please?
I think they're right there, so let me just take it.
All right, it's heavy.
Jury already coming out.
I'll just stick
Yeah, so go
All
ahead
right,
and sit it
the
back
jury.
down. Thank you. Subject matter jurisdiction still hasn't been proven for the record, Your Honor. Should be proven at some point.
Remind me not to do that twice. Thank you, everyone. Please be seated. All right, then I'll turn to the state. Any additional evidence at this time?
State has no additional evidence, Your Honor. May we make a record as to the exhibits?
Go ahead, please.
Your Honor, we believe that the court has admitted all exhibits that have been offered, with the exception of one prior ruling on Exhibit 6. I don't know if you want me to list them all by number or there are, it's 1 through 78, 1 through 178, but there are some numbers missing because we chose not to offer those exhibits.
Anything specific as it relates to the most recent testimony?
Most recent testimony, we with Detective Casey, we moved 177 and 178 and 175, 150, 151, 88, and 89. I believe those were admitted by the court.
That's my recollection as well, but for the jury, exhibits 150, let me start over. Exhibits 88, 89, 150, 151, 177, and 178. If I didn't receive them during the testimony, I'm receiving them now.
And 175, which was the still photo.
Thank you. Sorry, I had to scribble on my pad. And 175.
And 13 and 14. Those are the outliers. I apologize.
I believe those were received as well, but if I didn't
Objection, I
state
think
it,
they was already received.
I appreciate that. I just want to be thorough for the record. 13 and 14 were received as well. Do they have any additional witnesses to call at this time?
No, Your Honor, at this time, the state rests.
All right, thank you. All right, then at this time, we are going to break for the lunch hour. I am going to have everyone come back at 1:30. It's a little bit longer, at least that's what I want to do for the lunch hour today. So I'll rise for the jury.
Wow. So the state rests. True. So you guys, if you're in here, share the stream. Seriously, share the stream. We're gonna come back from lunch, and Darrell Brooks is going to have a chance to.
Thank you. Be seated.
He will open his.
Mr. Brooks, anything from you at this time, given the state is now rested?
What you mean?
I'm asking you the question. Do you have any requests at this time now that the state has rested?
What request and pertaining to what exactly?
Oh, the answer is no.
I'll ask the
Moving on.
question one more time. Do you have any requests to make at this time now that the state has rested?
I don't understand what you mean by that. That's why I'm trying to get clarification.
Then,
I'm
no,
not going
then
to
just
give you
move on.
legal advice. I'm simply asking the question.
Yeah.
Do you have any requests to make at this time now that the state has
He
rested?
feels like he should make a request, but he's like, oh, I don't know what to do because I don't know how to do law.
I don't know what I'm supposed to say to that. I don't understand what
the answer is no. Then move on.
would that be pertaining to?
I can't give you
don't
legal
know.
advice, sir. I'm just asking the question to make a record. I'll ask you one more time. Do you have any requests to make now that the state has rested?
I don't understand.
All right, the other thing I want to do when the jury comes back out is, you will recall I read instruction 101 at the very end of the preliminary jury instructions that just has to do with opening statements. I will read that with the caveat. It will just say that the defendant will now make his opening statement. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show you, so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statement is not evidence. So I'll read that if you think it's appropriate, given that Mr. Brooks deferred his opening statement until the start of his case. With that, we will take our lunch break. It's 12:09. If you could be back here at 1:25 and be ready to go at 1:30 with your opening statement.
I got a question.
Go ahead.
Do I get to present exhibits and stuff like that too and admit them into evidence?
At what point are we talking about? Do you want to use exhibits that have been received during your opening? Is that what you're asking me?
No, I'm saying if I got my own stuff that I want to offer into evidence, which is a question I asked previously.
Do you believe the state has all of those documents that they might be able to assist with? Or are they new documents?
I don't know what you mean by new documents.
Are they documents from the discovery that you have?
They documents of my filings and stuff like that. I'm sure they have copies of everything that I filed.
I guess without knowing specifically what you're referring to, sir, I did give you the admonition previously that you are prohibited from discussing subject matter jurisdiction during your opening statement. It's not relevant.
I'm not referring to the opening statement. I'm referring to things that I want to offer
Give me
for
an
evidence.
example, please.
I just did. I said I have filings that I want to offer into evidence.
That's too general, sir. I need a specific example so I can answer the question. What are you referring to?
My filings, everything
Which
that I filed.
filings, sir?
Every one of them.
Well, they have to be relevant, number one, to the proceedings. Okay, number two, I don't know specifically what you're referring to. You can't offer testimony of yours through an exhibit. That would be hearsay. So you'll have to testify if it's your statement that you're referring to.
I'm not referring to I didn't say anything about testimony. I said
I'm
filings.
being general based on what I've seen thus far. So are you talking about during your opening statement or during the course of the questioning of the witnesses that you're calling?
Your Honor, with all respect, I just clearly said filings that I filed.
Mr. Brooks, if I understood, I'd answer. I don't understand what you're asking me. You need to be specific.
I've filed a number of documents. I think that's on the record
without
that I
knowing what you're
filed.
referring to, then my answer is no. But again, well, I guess I'll have to wait and see as to when you seek to admit them, whether there's any objection or not, and whether they comply with all of the rules of evidence and the rules of procedure. That's the best I can tell you at this point.
I don't understand what you mean by that. They will only be relevant to obviously the matter. They would
Sir,
be relevant to anything else.
I can't answer that anymore. We're going to take our lunch break. It's 12:12. We'll see everyone back here at 1:25. We are in recess.
So I'm not allowed to offer anything in the evidence?
For the record, I never said that. We are in recess.
So I'm trying to understand.
He's trying to understand, man, the things that he is trying to understand. I can tell you right now. Yeah, he's got a lot he's trying to understand, but unfortunately he's a day late, dollar short on this one. You know what I mean? He decided to show up to court in the best efforts he could to be self-appointed attorney. And this is what we're looking at now. Now we're looking at him in panic mode, because now we're past the 11th hour. We're in the final hour now. It's all on him. It's there's no one else. No other state called witnesses that he can object to. There's no other evidence that's going to be brought up that he can try to pick holes in. Now it's up to him to bring that same information up, those same types of people, witnesses, for the state to go ahead and do the exact same thing to him. I've been trying to do a poll I'm having issues with right now, but do you guys even feel that the state's going to work on, are they going to do any, are they going to object to much of anything? Do you even feel like the state is at a point right now where they feel like they need to even say anything? I feel at this point the jury's got a pretty good idea of what's going on and what needs to happen. I don't think there's much that he could possibly bring in at all. Here's the thing: there's nothing he could bring in that would prove he didn't do this. What he's going for is finding a way to loophole it so that he won't get, charged for it. I think that there's slim to zero possibilities in all the creation that he's going to slide past that. So the questions that the poll that I put up, and maybe it'll come through here in a little bit, was: do you feel he's going for a mistrial, or do you feel like he's post conviction just going for the appeal, and everything that he's doing now is just building that appeal portfolio, so he has plenty of munition to bring to the fight on that one? So or is he going for the win? Is he going for the big not guilty? Of those three, I'd love to hear what you guys feel about that, because he's changed. It seems like he's changed his tactics a little bit. He's definitely he's got a plan, right? He's not coming into this uneducated. We'll give him that. He's read up. He's done his research. As much as it kills me to say these things, he is definitely working angles. He's got a plan. He's got a strategy, right? He's not just fighting blind, but he doesn't know how to do it. You know what I mean? It's like you could get coached up on how to step in the cage with a pride fighter, right? Hey man, he's got a killer right cross. He's got knockout power. What you need to do is avoid boxing him and take him to the mat, but you don't know how to wrestle. So the game plan, but you have no idea how to execute. And when you try to, you get punched in the face for it repeatedly. And that's kind of like what I feel is happening right now. And it's crazy that he feels at this point that he can keep pulling at the same threads, because none of them are working for him. None of these things are working in his behalf. It just more goes to show how much of a raging POS he is, and how backwards his whole entire platform is as far as his defense approach. So, but the judge is doing her part right now. Right now, she's telling him, like, listen, man, I'm not allowed to counsel you on how to do this. I can't answer your questions on what that means. I'm asking you, as far as court proceedings are concerned, this is next step. Do you have anything that you have questions about with this proceeding at this point? And what am I supposed to question? What am I supposed to, argue about? Because he's feeling it now. Now is the point where that collar gets loosened up a little bit and he starts sweating, because there is just share the stream, you guys, and sit tight. We're going to take a lunch break. And we'll be back with the second half of this. Before we do that, though, I want to go ahead and give you guys, there's a couple videos that I wanted to pull up and take a look at with you. If I still have those floating around here. I'm just stoked for this one to pop off.
Did you just say mind-boggling?
Yeah, mind-boggling. When things are so crazy, it gets your thoughts all trapped like in a bottle.
I'm going to pop that one out after lunch. He said it so many times, and I was trying to get that video set up and made, but it didn't get a chance to get it out there. But we do have our judge.
That was before the
Don't get brazen with me.
Don't you get brazen with him. I wish that the judge would have dropped that on him. Don't get brazen with me. That would have been amazing. It'd have made my day. Unfortunately, she's having to play her cards the way she's doing it. Stana says, Stana, am I saying that? Stana with what the jurors have seen thus far, it's pretty evident. If I were to go off of only what's been presented to them and seen the weapon with my own eyes, I think they'll wonder just what in the world he's going to say today. Yeah. Same question I have too. Like what is he possibly going to bring up? Donna Moore on Facebook says, I think he thinks he is going to put loopholes in everything, and he's just making the jury think he's just a troublemaker and probably should have been locked up way before now. We all know he should have been locked up for a litany of different crimes. Let me see. Gail Cox says he will definitely say mistrial. Maybe that's why the judge is making sure he's got. Yeah, so she is definitely being careful to avoid any mistrial opportunities, which is why she hasn't, sequestered him into another room. She's working really hard on not holding him in contempt. And I'm sure that there's 100%, probability that would lean in his direction, because he keeps saying, you hold me in contempt, you hold me in contempt, because then he wouldn't be able to defend himself as himself, not being himself. So, anyway, Alex Koziol says most of his plans have been debunked. The horn's gone, brakes gone, not him gone. Yeah. So there's nothing much. I mean, does anyone have an opinion on anything on what his counter offer is for a plea? Yeah, Abigail, that's what we're talking about. What direction is he going to go with it? Nobody knows. I mean, I don't know for sure. I mean, I've got my thoughts as to what he's going to try to accomplish, but I'm with you guys. It's I feel like 100% probability that it'll miss the mark and he'll end up, dealing with the full leveraged consequence or sentencing for the crimes he's committed. So, that's where we're at. It's wild to me. We had yesterday or on Tuesday, I believe. Let me see if I can pull this up for you guys real quick here. We had a couple videos that went through that were they're not going to pull up for us right now. That's okay. That's all right. I know there's a lot of thoughts in here as to what I clearly stated to the judge. I'm not. Oh, okay. Sorry. You guys be cool in the chat. You guys are cool with each other. You know what I mean? We're all in this community. We're all just trying to, work through this together. The thing about him being so combative with her, I think is a big deal. Like he's going at this with her as a female judge, I think is interesting. If it were different, if it were like Judge Schroeder or a man. And I'm not saying that because I'm not saying a man would be better in this position than a woman. That's not what I'm saying. What I'm saying is his view of women is obviously just horrific. I mean, the video we watched of him talking about, I was pimping her out, blah, blah, blah. She's 15. He took her from her hometown to Las Vegas and I was pimping her out. Then I got her pregnant, and then I got charged with rape. And so his view of women, obviously, for his entire life has been horrific. And he looks at this judge as an authority figure, this woman who's got the power to tell him to sit down and be quiet. And the only thing he can do is keep talking and not sit down. Those are literally the only two things he can do. And then she's able to, up to, the last several days, put him in timeout and then make him hold up his little objection sign and go from there. And, that's what it is. Marianne Jones says, I think he's going for mistrial, also trying to prove he's nuts so he can use an insanity. They've thrown out the insanity plea. He's not going to be able to use that one because that was first what they were leaning on, but they tossed that out. Then they had the specialist, after doing their, Q&A, ink blots, whatever they do, they found that he was competent to stand trial. So it's definitely a situation where he's very competent to be in, and he's showing that, he's, as the judge said, intelligibly, asking questions, and it'll be interesting. It'll be very, very interesting to see where this goes after lunch. So we got an hour break, you guys. I would encourage you all to get some food, get some water, get some coffee. I'm going to step away for a brief moment, but I will be back. I'll shoot up a post when I do, and hopefully you guys are going to still be in here with me. And we'll jump back in here in about, I think they said they're going to take it. So we'll check back in at 1 o'clock Central Standard Time because it looks like it's about 12:23 right now. They're going to take a 45-minute lunch somewhere in there, and then we'll be back. So, yeah, sit tight, you guys. I might end up if you keep the stream on. I don't want you to have to sit with dead air. Set up notifications on whatever, and then go to the bell or whatever and set up all notifications. What I might end up doing, because this trial is probably going to go long and it cuts me off at a certain timeline or a time frame, and so I don't want it to just kick us out if we get to the heated end of the day. So what I might do is a part 1, part 2. So if you see this, we'll probably knock this into part 1. I'll cut the stream and then we'll come back up for part 2. When we come back from lunch, and then you should get a notification saying that we're live again. And we'll go off of that. That's actually what I think I'm going to do here. We had talked about possibly doing a supporter and a members only chat for a little while. We're going to avoid that. I think it caused a lot of confusion. And, but I want to explain that real quick while I got people in here. The supporters, you guys, if you become a supporter, it's $4.99 a month. And what the supporter group does is it's a recurring monthly support, contribution of $4.99. You guys, I really would love it if you all would become supporters. I need the supporters group, because what that does is help me plan ahead, pay the bills, keep the lights on, pay for all of this, the travel, and and it keeps this all running. Not to say anything other than the fact that I put in thousands of hours, but even this, the hours that go into the prep for this, the hours that go into the follow up, and then the 8 to 10 hours of stream time. I know we're all in this together, but it takes a lot of effort, and the supporter group, that supporter channel helps me know how far I can go with things. It's $4.99 a month. It's, less than a cup of coffee this day and age, and it's pennies on the hour for what I'm trying to give you back in return with with all the stream offerings that I provide here and everything else that I do. So become a supporter, you guys, and I do appreciate everything else, the super chats, super stickers, and the stars, you guys. That also makes a huge difference. The stars, please keep them coming. I've never been really good about pushing that platform of hey, I'm viewer funded, but I'm viewer funded. I work my ass off to make sure you guys have the best that you can get, and you guys work hard at being a part of this community. So thank you very much. Become a member on YouTube if that's the channel of preference. There's special things that come along with that as well, perks and bennies. We're going to be doing some breakout sessions, some one-on-one Zoom calls, just things that'll give us a chance to really make it more personal. And also, again, it's paying into helping grow this channel and this platform, which I'm hoping to continue to give you live coverage at events. Obviously, that's what I've been doing. That's what I'm known for. But also in these studio feeds where we're able to kind of get in depth and to take a little bit more of a microscopic look at what's going on and what we can do about it, and how we can, work with it. So that being said, you guys, again, one last time, thank you for everyone who is a supporter, everyone that is a member on YouTube, everyone that's contributing right now through stars, through super chats, super stickers, whatever it may be, direct contributions right here on Facebook or on YouTube. You guys really do make it possible. So I'm going to go ahead and do what I do. But I do it because I love it, you guys, and I really do like being here. So set up notifications. If you do anything, just share the stream. That means a lot too. Just share the stream. Send it out to some groups you got on Facebook or friends you might have on whatever channel you watch on. But I'm going to go ahead and take a quick lunch myself, and I will be back with you guys here very, very soon. So sit tight and set up notifications. Change my mind. We're going to stay on here. I'm going to keep you guys on the feed here. And I don't want to break the feed here. So if you jumped out already, you probably won't get a live notification. I'll put up another post on Facebook when I get back, so you guys have that. And then we'll go ahead and I'll make sure to try to give you notification that I'm back live again. But I'm going to keep it running. So you're going to see the dead screen for a minute here. And, well, not dead screen. We're going to give you guys this screen here, which will be the slow TikTok reminder that we will be back soon. Here's a fun video of me getting tased down in Portland. This is fun.
Okay, if I had a bong for my chat, you would get it.
Hello. It's official now. I feel like the later the night goes, the more my laugh sounds like Seth Rogen. So,
Yes! Got it! Yeah!
Good times. Good times. Yeah, that was me getting tased. We had all sorts of people that would donate money while we were doing our feeds down during the protests and riots in Seattle and in Portland. When I was trying to generate funds to get to DC, which ended up taking me to Kenosha for all the events of 2020. People would like donate money to my team or people that were around me. Like, hey man, we'll send $10 if you tase CJ. And so I'd be doing my stream, doing an interview, and then I'd get zapped in the arm, zapped in the leg, taken in the butt cheek. But yeah, there was a lot of tasing going on, which adding that to the tear gas and the pepper spray, yeah, it made for a very interesting summer of 2020, man. Was nonstop. I've got a bucket, I tell you guys, legit, like a bucket full of munitions that I was hit with. Bean bags, I was hit with rubber pellets, rubber bullets, impact batons, these big old, just things that made you feel like your internal organs were exploding. Anyway, yeah, Adam was down there. That video had when streamers were all cool, we were all together, we were all just there filming, and then things became very diversified and exclusive, and and people became kind of puppets for certain sides. And I just let everybody know, like, hey man, source your information, you do you. I'm going to keep asking questions of me. This is how I am. But yeah, that's when we had Adam RX, we had Soul Luna, we had Eric Greatwood. I was with Concrete, we were doing that with Ian and Shay at the time. We had at Concrete Reporting Days, yeah. Man, there was so many more down there. And the Boob Troop was down there. Yeah, we had and we had Baloo, you guys, we had that summer there was a lot of love in that stream community, and it's sad that it went the way it went. But when I come back, if we have time before, I'll show you guys some more clips from Portland from the summer of 2020. But for the time being, we will be back shortly, you guys, and make sure to keep the notifications set up so that if I do have to send a notification to get people back in or get you back in, if you have to leave for any reason, we'll be able to do that for you. So I will talk to you guys. thick of the crowd. I'm going to stay up with them so that we can catch what happens up front here as it happens. So I'm going to jog a little bit, guys. Get a little choppy for a second. This is right back where it started last night, guys. You know that, right? Like we were here for 12 hours. What you see in front of us are those burnt down. Oh, wow. Holy shit. Wow. Hey, guys, definitely want to share this stream. This is... Oh, immediately it's starting.
CJ, right?
Yeah, oh, hey. Yeah, we talked earlier, yeah.
Talked to you yesterday. Good shit.
I appreciate you. Thank you so much, man. I appreciate you guys letting me be out here with you.
Yeah, most definitely.
Man, it already looks like a straight up recycling bin out here in front of these police. Some rocks are getting thrown. If any of these people in front here don't have helmets on, they need to back up. Because those are, they're going to get hurt. Legit going to get hurt. You guys, normally I'd be right up front, but I don't have a helmet with me. Didn't get a chance to pack it with myself from Seattle. So, but this group back here is just growing and growing and growing. There's already like 5 people here. Yeah, we're good. We're good. Oh, they're shooting out of the turret up top. There it goes. Here comes the tear gas. They're going to allow those back into the crowd. We'll put some protective eyewear on right now, guys. You can see the tear gas already going off in the distance there. Look at your stream. Pardon me. That guy got hit. He's hurt. So not a lot of people got the leaf blowers out there. Usually they'd be getting shot by now. You got fully automatic weapons leveraged at the crowd right now, just behind these less lethals. Whew. In this crowd, guys, you can't see them right now, but around behind us on the other side of the street, I don't know if they're planning on clashing with these police tonight or if they're going to take us to the straight to the streets. No, Steph, I'm good at the moment. But if I could get that real quick, honestly, just in case, I'd appreciate it. That phone. Yeah, I got the helmet. Oh, damn. Holy shit. Not right now, though. I don't need anybody else coming in here right now. This is not a safe place for anybody. I've got a gas mask. I'm going to cut the comments for a minute, guys, just so I can go ahead and see full screen of what's going on right here. here with Andrew Mercado on the footsteps of the, I think it's the courthouse, right? The, what's the name of the courthouse? It's the federal courthouse right here. And there's probably, I don't know, how many would you say, Andrew? A couple hundred police, maybe at the most, and 1,600 plus protesters. I got some PPE here, and I've got, so I'll be able to operate. Right now, I'm gonna walk around a little bit and see if I can get a good look at the line here. While there's a little bit of calm right now. I don't know if everybody's just taking to the streets. It looks like everybody has now moved off. Now, the crowd we were with didn't seem the type to protest. I don't know what's going on the other side of the park, but it doesn't look good. I'm gonna keep this mask down for now. So this is what we're looking at right now for the police line formation. Combination of state police, I'm guessing local police, sheriffs. And they've definitely that's the Kenosha County Courthouse, just so you guys know. That's where we're at right now. So yeah, they've been flashing, they've been popping these things already. Here's one of those impact batons right here. Thought that one was gonna go off. These guys right here, these impact batons, yeah, these are the 40. Yeah, these things actually are marking, and they got dust in them. They got that pepper spray or pepper powder. So they've definitely leveled up on their defenses right now. But as you saw, man, those mortar shells that were hitting them were huge. That's a two-banger, as they call those things. He said, ow. Damn. Oh, wow. That one was right off the shield. They're going for his nuts. Like there, so you see the laser dot on his ball bag? Are they breaking into buildings as well? Is there looting happening down the street? Pick's not clear. You don't look blocked, Kelly. You got some dude up there just sweeping with a broom that's on fire. You seeing that? Just sweeping the ground. Somebody take a screenshot of that, please. Just sweeping away with a burning broom. You can hear the drones they got above us. So you got the sheriff rescue vehicle. You got the SWAT vehicles as well. I don't know if this is just the last stand, last of the people that are here, or if everybody else is off, engaged in other activity in the city tonight already. Excuse me, man. Pepper gas is pepper spray and all that. This guy with his broom, man. Damn. I don't know if that's the LRAD right there, but it just pivoted like an angry robot. That's the long-range acoustic device is, I think, what's going on there. Unless it's a jammer. How you guys, can you guys still see everything, hopefully? Yeah, I don't know if that's a jamming type thing they got right there or not. Ooh, that was a brick that just hit those cops. Shit. Oh, here they go.
There's a fire. You can see the fire started in the distance there underneath that truck already. And I don't know if that's...
No, I don't need Kay's phone at this point. Not right now. Hopefully you guys can still see the screen all right. And the feed's okay. There's that truck fire. Hey, that's one that wasn't burning yesterday. And it's already started. It sounds like they got a rally going in the park. So people are rallying back here. All right, cool. Thanks, guys. That's because I think this guy's got a backpack feed right now. Yeah, I'm gonna go over here and take a look real quick. I'm gonna try not to get shot by these guys as I walk behind these guys. So the fires have already started tonight. I don't know if they're planning on taking it to the streets, but it's safe to say that, I think we all know how this is going to go. You got drones overhead, helicopters overhead, 4 or 5 SWAT vehicles. You've got fires burning in a probably 500 people, 350 to 500 people out in the park right there that are gathering and rallying. Yeah, I'm downwind from that that tear gas. So.
Well, the battery died in the vehicle. Well, that's not a good look.
So they got the garbage trucks on fire over here, and apparently the sheriff vehicle battery died. So I wonder if they plan on jump starting that thing. May have to pull one of those around. Give them a hand. Or they're just lining up the turret so they can get a better shot on the crowd.
Hold up, y'all. Come on. Come up. Stand. Stand on the line.
Those little clouds you see, those little poofs, they're a paintball basically, but it's full of pepper powder. So they hit people, they pop like 3 meters worth of, or 3 yards worth of pepper powder. Look at this monster, man. This is a...
Hold up. Oh, shit. Damn, everybody's getting hit right now. I'm having to hide behind a pole because they keep shooting at me, too. Whew. One of those impact batons just nailed me in the back. That one right there. Oh, my God, that shit hurts. They're going to push those cars out of the way up there, it looks like. Oh, the fuck. Right in the back, man. That shit right there. They come out of these cannons and they shoot them. They're like 40 millimeter cannons, basically. But I mean, I understand where I'm standing is not a safe place. It's gonna happen. It just hurts like a bitch.
Like, these guys don't think they're the bad guys. No one does.
Whew.
How do you piece together the story versus these guys aren't the bad guys?
Ooh. Someone take a screenshot of that, please. They got that small group of people up here that are, I gotta take my mask off, that are hiding behind some umbrellas and makeshift shields that were up here. I think they were the ones that were standing in front of the Bearcat that's behind me. I think it's called the Bearcat, actually. I'm not sure what the technical name is for that. Y'all can take a screenshot once it's got it. There we go. Gets out of my shot. Figure it out, bud. There he goes. Right there, that right there. Appreciate it, guys. Hey, for everyone that's tuning in with me, we're in Kenosha, Wisconsin right now. Day 2 of this standoff between law enforcement and these people that are here in Raleigh about the gentleman that was shot yesterday by the police. And last night we saw it, how we've seen it in many different situations. This one was much more unprepared, unplanned. It was definitely, you're not seeing a lot of gas masks in the crowds. You're not seeing a lot of helmets, much like you would see in a typical situation like in Portland. What you do have right here, though, is they've doubled down their efforts for the law enforcement side. But if you guys tuned in last night, which most of you probably did if you're watching right now, you saw that car lot burned to the ground. You saw that building burned to the ground. I mean, a full-on riot. And this started off with, there was probably 500 people in the park already that were clashing with the police behind me. And then you had all of the people on the march that came with us as we marched with them up to this courthouse square. And there was probably a good 750 with that as well. So the crowd is definitely thinned here in front of us. As to where everybody went, I don't know. It could be spreading into the city. And as we came in, we saw, Andrew and I were seeing that all the businesses that we saw in city buildings were all boarded up. Pretty well. So we're just hoping that, I hope no one gets hurt tonight. And I definitely hope that it doesn't end up making its way into the city out here and seeing businesses and people's personal property destroyed. This guy looks like a linebacker, like Viking warrior over here, like a steampunk Viking linebacker. Maybe not for the Vikings. I'm not trying to rep for them. Sorry, y'all. That's Andrew's squad. Anyway, I'm gonna shut up. I gotta share this stream. Let's get the word out. Let's let everybody see what's going on right now. So we have like these little groups. You have one pocket right here that's moving up, they're starting to grow in numbers right behind it here. And then they're going to clash with these guys down there in the distance. You can already hear them. They're popping off rounds still at people that are throwing rocks and other debris at the police on the far end of the line over there. And then, of course, right behind me, guys, is that Bearcat.
I swear.
What's up?
What's up, y'all? I'm Kenny.
It's Kenny.
Check out Image Theory Photography, everybody.
There it is. You guys heard it. Image 3?
Image Theory.
Image Theory Photography, y'all. He's going to be catching a bunch of filthy stuff tonight. Hopefully some stuff from me and Andrew as well we can use for our profile. My man.
I'll be sending it out to you guys.
Kenny right there. Image Theory Photography, y'all. So it just blows my mind. Their battery died.
Did it really?
Yeah.
Their battery died.
I thought this guy was coming around to give him a jump, but I've got the Halo in my backpack. It's good for jumping a semi-truck, apparently. But I'm not going to make that offer. I feel like it would definitely send the wrong message right now, yeah. All right, there the crowd's growing now, y'all. So everyone's starting to get to the front. They're trying to start this with a lot more effort.
Bad luck, bro. It's called being a bitch. It won't start.
I'm gonna get a chance. I'm gonna come over here and take a look. Hey, you might have to stay a little bit away from me, man, just in case. You see an impact round right there? That's that shotgun you see. Those are those sandbags, the squids that we were looking at last night. So right here you got these trucks are already on fire. Excuse me. Sorry. Bless me. Man, pepper or the tear gas, some people get used to it, not me. There you go, there's a screenshot as well. DJ over. It's like a beat drop situation right there. Hey guys, thank you so much, Randy. Everyone else for those donations, we really appreciate it. It does make a big difference in helping make this happen as we continue to move forward on our trip to DC on the 28th, which is where we're going to end up. As good time as any before things crack off right here in this moment. Andrew Mercado and I are tag team, and we're road tripping from, we'll start in Minneapolis. Oh, that's all it takes, one water bottle. Started in Minneapolis, and we're making our way all the way to Washington, D.C. For the March on Washington on the 28th. this coming Friday.
It's water. It's water. Point up to the sky, bitch. It's water. Oh no, the sky is falling. Oh no, another water bottle. Oh, that was Snapple. Sorry. That was Snapple. Sorry. More water. Go home. I can't stop these people for you. There's shooters out here, bitch.
You hear them down there, they get pop, 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 pop. So they're shooting those pepper balls down here. I don't know how dark it is there, guys. There we go.
I got shit else better to do. We gonna burn the station. Hey, y'all go in that field. Go in that field. Not us.
Sorry, man. I don't know if you guys see this. I'm gonna show y'all. I've got my back right up against this tree because there's some bottles and everything thrown right at my head, around my head. I'm gonna try not to get hit. I don't have a helmet on right now, and I wish I did because big ass glass bottles hit the tree above me. There's Snapple bottles on the ground, liquor bottles. There you go. There's.
Fuck, here comes the tear gas.
Fucking hate tear gas. Hey, do you have any water? Water? Do you have water? Anybody got a water bottle? Nah, I just need a rinse. Sorry, guys. Hold on. I'm washing the pepper spray out of my eyes. You got to make sure not to touch it, though, or rub it. Dab. And then dab. Fuck that stuff. Apparently, a tree is not an adequate device to hide behind in order to stop tear gas. I need some earplugs now, man. I didn't bring those either. I wasn't expecting them to use the LRAD. So you have a long-range acoustic device going right now. And that thing gets louder. Whew, I'm sure it's loud for you guys. And I can't really look at comments too much right now. I can't see much. Even the gas mask I have doesn't stop all the gas from getting through. So, yeah, it's loud, guys. It's going to be loud. Turn your volume down on your TVs. Yeah, if it's hurting your ears, you can imagine how loud it is out here. Oh, yeah. DJ Elrad. Mix in those nighttime bleed. Oh, there you go. Giving everybody those mellow moods of protest. Okay, so they just announced where the medical attention is. Nice. That's good to hear. So what everyone's saying is if you know anybody out here and you're out here right now, guys, if someone needs medical attention, they're down the road on, I didn't hear exactly what the name of the street was, but down behind these medical attention. Here they go. They're about to say, but they do have medics out here that are willing to help. So if anybody gets tear gassed, if you get pepper sprayed, keep in mind that there are people out here with things they can use to help counter that chemical burn. That's going to be, it gets bad. I've been hit several times. You guys have seen that if you know me and you're watching me. And definitely tear gas it's tear gas. It makes me sad. Just saying.
Walk away from the vehicle. Walk away from the vehicle.
Hold on, CJ. Oh, what's up, my guy? How are you?
We've been watching you
for hours. Good look. I appreciate you guys. Thank you. Sorry I'm wet. I had to douse my eyes out. I got tear gas right here. Yeah, the mask is help. I mean, it helps. I was able to breathe through it. The filters I have aren't exactly super intense, so you can get different kind of filters. And I want to hear what people are saying right now. Sorry, I'll be all right, guys. I'll be all right. I think that when they say that, they might be talking about the burning vehicle. I think they're afraid it might explode. What? You put these masks in.
Congratulations. You make Kenosha another shit stick.
And that bottle almost hit me in the head. You gotta be careful up here without a helmet on. Yep. Trying to keep my back to this tree here for now. And even through this mask, guys, you're still getting. Oh, so here comes the backup. Oh, sorry, I blocked the view. My bad. Thank you, Michael. Again, all your donations are appreciated, guys, and much needed as we get through this. All right, you guys okay? You okay? Oh, thank you for that as well. Oh. They don't want people picking up the munitions that they discharge. So, hey, note to anybody out here, don't try grabbing stuff in front of them, even if it is a canister. Those things are wicked hot. They will burn the shit. They will melt your hand. No joke. I filmed one yesterday, and you can see it rolling across the tarmac, and it was melting all the rubber, or the tar. You see the guy in the front of that vehicle leveraging his weapon? Leveraging, whatever. You know what I'm saying. He's taking aim, and he's about to hit someone. Now, the shotgun rounds, it is a shotgun what you're seeing, but it's a less lethal, they call them. And those things, they shoot salt rounds. They shoot those impact rounds, those squids, what are sandbags. And I'm sure a litany of other things. I mean, I can only talk about stuff I've been hit with. So I'm curious who the guys in brown that just came out are. We're going to take a walk over there and see, okay? I'm going to have to move to the side, though, so I don't get hit by anything. Because every time I move, more things get thrown. All right, we're going to try to make a move now. So bear with me, guys, real quick. All right, they're reestablishing their battle line. Yeah, so you guys are hearing those bottles breaking every time I move. Not just because they're throwing at me. I'm just saying I've got a pole to my back, which is providing. I'm not a small person, guys. Like I'm wide, probably as wide as I am tall, and I'm an easy target. Not that I want people to use me as a target or a shield. Just saying. Hey, thank you, Eric. I appreciate that. I did not know that, Dorothy or Crystal. Sorry. Yeah. So I'm going to show you guys the back right there. You can see that a shield wall forming in the back there. Not like what we're used to seeing up in like Portland, where they have 50 shields deep, all uniformed. And sorry, guys, there's just still a lot of tear gas in the air where I'm standing. I don't know if you can see this down here at the end there. You can hear those impact rounds. They're getting shot, and the pepper bullets, or the pepper rounds. I'm not sure who this new line is that came in. They're calling me Umbrella Shield. But man. Here comes the next a bottle. Okay. Oh wow. We got to see this fire over here is just raging out of control. It's spreading down the street as all the fluids are leaking out into the street. A screenshot moment as well. What's hard about this crowd too is the second that someone around you does something, immediately they're gonna get shot at. And if you just happen to be standing there, this guy with the light, they got the green light on him, right on his face, like right on his forehead. They put it right in his eyeballs. Hit him with the laser right in the eyes. He's shining a light in the face of the officers. And you see that oven mitt he's got on? He's wearing that so that he can pick up tear gas canisters and flashbang. I wouldn't say flashbangs, but tear gas canisters and throw them back at the police. And if you could hear this. There's that LRAD in the background. Looks like they're pushing the line here. Hey, Sherry, thank you so much. You guys, seriously, thank you everything for all you're doing. Help make this happen. So you got these guys there. You got that going on there. And you got all of that across the street over there. And then everybody else in the park over here. Mondays. I'm gonna get up here with Mercado real quick. Holy shit, what is this? Is that a pipe bomb? Oh, looks like a pipe bomb. Or just a pipe.
What is it?
It's a pipe bomb. It looks like, I mean, I might be wrong. It could just be a pipe.
A fucking pipe that blew up on its ends. That's my guess.
It looks like it blew up. That's crazy. It's like a makeshift pipe bomb. Hey, did you see that? The remnants of that pipe bomb over there?
Yeah. Yep. I saw the pipe bomb. I think we've established that make sure you keep showing them your badge, especially that. Yeah. You gotta keep showing this. Is that way they can see it? Yeah. That way they know. Yeah. That way we can film them. You know
Oh yeah,
what I
no,
mean?
I'm with it. Yeah, they I've been clear about up front who I am. Yeah.
I know, though. Welcome. Look at that on YouTube. That's for YouTube, dude. Get out of here. So, you guys can either listen to the LRAD like it is right now, or you can mute it. It's up to you guys.
Oh, you can mute it on yours?
Yeah, watch.
Wow. Then they miss out on DJ LRAD. I think everyone on my feed loves the DJ LRAD.
You guys like DJ LRAD? I don't think he's DJ LRAD ain't playing. He's not talking. He's just playing the siren right now. So if you guys want to listen to that, you can. If you can mute it, there you go. It's off.
Hey, Paul, I can't see who else just sent one through. Thank you so much.
People say leave it. All right, I will leave it.
Angie, thank you so much.
Help the users that don't know how to mute or turn the volume down.
Sherry, thank you so much. I appreciate you. Jordan, man, hey, all that love and appreciation, guys. Thank you.
Would be, who would be called on what day?
Why don't I have the state write down who's here presently, and then you can make that determination, but at least let's go with the opening statement, okay?
That's what I was trying to get at. It would help to know who's actually here today.
Before you make your opening statement?
Well, so I know if they're not here, then essentially I can't call them.
Let's address that after. I'll have the state write down who they know to be here now or who's coming this afternoon, because there might have been people here this morning. I believe they're still here, but I'll let them write that down for you. So you
All
can
right, we're
better
back. Sorry,
prepare.
guys. Share the
But
stream
at
if you would,
this point,
please.
I would like to bring the jury out for your opening statement. I presume you're going to give one.
I am.
Okay. Then
Yeah.
I'll have the jury brought out, okay?
Subject matter jurisdiction.
My prior written decision stands. I will not be addressing that further. Your objection is noted.
Nonstop, the subject
And I
matter
will be
jurisdiction.
continuing with the trial.
Is it verified proof for the record?
Sir, I don't believe I
You
need
guys
to do that.
share the stream,
Or
please,
that
because this
the
is,
state
like I
needs to
said,
do that
definitely
as
going to be
well.
one of the most like.
Your statement about that is a misstatement.
This is an M. Night
of
Shyamalan
law,
situation. We're going to see.
And
the
I do not
twist.
intend to pursue
I think.
that
I
further.
hope.
Can you show me lawful law that says that?
I gave
Lawful
you a
law.
written
Who wants to see
decision. I
lawful law?
have done that.
Can you show me lawful law that verifies that
Sir,
for the record?
I gave you a written decision. You
that
can,
I accepted for value in return for
and
value.
that's how I'm going to answer that. So
it was
let's
not verified proof. We still aren't.
Sir, there is no requirement in the law that the state or the court establish that. So your
Actually, there
objection's
is.
noted.
Actually, there is, Your Honor.
Did you just say mind-boggling?
Yeah, mind-boggling. You know, when things are so crazy, it gets your thoughts all trapped like in a bottle.
Has to be proven. Has to be proven. You know that.
Sorry, that's just how
he
keeps saying it's
Brooks,
mind-boggling.
Please
Mind-boggling.
do not make statements that mischaracterize the law
You know it has to be proven
or that
for the
impugn the
record.
integrity of this
You know it
court
has to be
and
proven
the
on the
proceedings
record.
here.
You know
The
it
jury
has
is
to be proven.
advised to disregard the statements that Mr. Brooks is making regarding subject matter jurisdiction. They are not evidence, and you are to disregard them.
Okay, guys, we are going to, like I said, we're going to end the broadcast and then come right back in. So
The jury
sit tight
will
as we get the jury back
disregard
in,
the
and
incorrect
I will see you all in
statements of the
2
law that
seconds.
Mr. Brooks is stating.
Where's lawful